The Rajasthan Transparency in Public Procurement Rules, 2013. RJJR HanJLCK, QJL JLCW JLJD SF SRA FJLJ, 2013. Additional context. This paper delves into the intricacies of public procurement regulations in Rajasthan, India, specifically focusing on the Rajasthan Transparency in Public Procurement Rules, 2013. This work builds upon the foundation laid by the Rajasthan Transparency in Public Procurement Act, 2012, providing detailed rules and procedures for implementing the Act's provisions. Public procurement, simply put, is how governments buy goods, services, and works from private companies. It's a massive sector, accounting for a significant chunk of government spending worldwide. Ensuring transparency and fairness in this process is crucial for preventing corruption, promoting economic efficiency, and building public trust. These rules address key aspects like procurement methods, bid process management, integrity codes, and appeal mechanisms, aiming to streamline the process and make it more accountable. This research fits into the broader field of public administration and governance, specifically within the sub-area of public procurement. It connects with existing research and policy discussions on improving transparency, efficiency, and accountability in government spending. For example, globally, organizations like the World Bank and the United Nations Commission on International Trade Law, UNCITRAL, have developed model laws and guidelines on public procurement, which many countries, including India, draw upon when designing their own regulations. The rules outlined in this document likely reflect international best practices adapted to the specific context of Rajasthan. Furthermore, the emphasis on e-procurement aligns with the global trend towards leveraging technology to enhance transparency and reduce opportunities for corruption in public procurement processes. Ultimately, the effective implementation of these rules can have a significant impact on the lives of ordinary citizens. By ensuring that public funds are spent wisely and transparently, the government can better deliver essential services, promote economic development, and foster a more equitable society. This work contributes to the ongoing effort of strengthening governance and promoting sustainable development through improved public procurement practices.
Table Summary. This table provides an index of the Rajasthan Transparency in Public Procurement Rules, 2013. It lists rules, their particulars, and corresponding page numbers, organized by chapter. The table describes different methods of procurement, bid process management, code of integrity, appeals, and forms. It also includes the particulars and page numbers for each rule.
1. Rajasthan Transparency in Public Procurement Rules, 2013. GSR 96. In exercise of the powers conferred by Section 55 of the Rajasthan Transparency in Public Procurement Act, 2012, Act No. 21 of 2012, the state government hereby makes the following rules, namely: Chapter I. Preliminary.
5 definitions. Definition 1. Competent authority. An authority or officer with the delegated power to make decisions related to procurement matters. Definition 2. Swiss challenge method. A method of procurement where an unsolicited proposal for a project is submitted and third parties are invited to challenge it through open bidding. The original proponent can then match the best offer. Definition 3. Project proponent. A legal entity or person who submits a proposal for a project under the Swiss challenge method. Definition 4. Eligible sector. The specific areas or industries in which project proposals are allowed to be submitted under the Swiss challenge method. Definition 5. State-level empowered committee, SLEC. A high-level committee constituted by the state government, often chaired by the chief secretary, to consider and approve projects received under the Swiss challenge method.
1 short title and commencement. 1. These rules may be called the Rajasthan Transparency in Public Procurement Rules, 2013. 2. They shall come into force on such date as the state government may, by notification in the official gazette, appoint. 2 definitions. 1. In these rules, unless the context otherwise requires, Act means the Rajasthan Transparency in Public Procurement Act, 2012, Act No. 21 of 2012. 2. Competent authority means an authority or officer to whom the relevant administrative or financial powers have been delegated for taking decision in a matter relating to procurement. 2 Roman 2a, earnest security, means an amount of security provided by the project proponent to the administrative department concerned as a token of sincerity and good faith, as specified in Subrule 6 of Rule 79F. 2b, eligible sector means the sector, as specified in Rule 79B, in which the project proposals can be accepted under the Swiss challenge method. 3. Form means form appended to these rules. 4. International competitive bidding means a bidding process in which qualified bidders from all over the world, except those having nationality of a country declared ineligible by the central government, are allowed to participate. 5. National competitive bidding means a bidding process in which qualified bidders only from within India are allowed to participate. 2. 5a, project proponent, means a legal entity or a person who submits a proposal under Swiss challenge method. 6. Section means section of the Rajasthan Transparency in Public Procurement Act, 2012-3. And 7. State-level empowered committee, SLEC, means the state-level empowered committee constituted by the state government under the chairmanship of the chief secretary for consideration, examination, approval of the project, received under Swiss challenge method. 2. Words and expressions used in these rules, but not defined, shall have the same meaning as assigned to them in the Act. Chapter A. Organizational structure for procurement.
6 definitions. Definition 1. Procuring entity. Any government department, organization, or body that is making a purchase or acquiring goods, works, or services through a procurement process. Definition 2. Bidding documents. The complete set of documents that a procuring entity provides to prospective bidders, containing all the information and instructions necessary for preparing and submitting a bid. Definition 3. Procurement committees. Committees constituted by a procuring entity for various procurement-related tasks, such as preparing bidding documents, opening bids, and evaluating bids. Definition 4. State Public Procurement Portal. An online platform maintained by the state government to provide access to information related to public procurement activities, ensuring transparency. Definition 5. E-procurement. Procurement processes conducted electronically, often through an online portal, to enhance efficiency and transparency. Definition 6. Consultant. An individual or firm hired for their expertise in a specific area, typically to provide advice, project management, or technical assistance.
3. Procurement committees. 1. Every procuring entity shall constitute one or more committees for the following purposes, namely: A. Preparation of bidding documents, B. Opening of bids, C. Evaluation bids, D. Monitoring of contract, E. Spot purchase, F. Competitive negotiation, and G. Any other purpose relating to procurement as may be decided by the procuring entity. 2. Each committee shall consist of 3 or more members, including senior most accounts officer or official of the procuring entity, and if required, a technical official may be nominated by the procuring entity. A consultant, as subject matter specialist, may also be nominated in the committee by the procuring entity, after recording reasons, with the prior approval of the competent authority. 3. In complex projects, the work of preparation of project report or bidding documents may be assigned to consultants with the prior approval of the competent authority. 4. State Public Procurement Portal. The State Public Procurement Portal, in addition to information specified in Clause A to G of subsection 3 of Section 17, shall provide access to such other information as may be specified by the state government from time to time. Every procuring entity shall upload and publish the required information on State Public Procurement Portal maintained by the State Procurement Facilitation Cell. 5. E-procurement. All subject matters of procurement of an estimated value, as may be notified / by the state government under subsection 2 of Section 28, shall be procured through e-procurement. In such cases, every bidder shall deposit user charges as may be fixed by the state government, from time to time. Every bid shall be digitally singed by the bidder. The The procedure of e-procurement shall be as specified for this purpose on the State Public Procurement Portal. Chapter II. General Principles of Procurement.
11 definitions. Definition 1. International Competitive Bidding, ICB. A bidding process where qualified bidders from around the world are allowed to participate, promoting international competition. Definition 2. National Competitive Bidding, NCB. A bidding process where only qualified bidders from within India are allowed to participate. Definition 3. Unique bid number. A unique identification code assigned to each procurement process for tracking purposes. Definition 4. Procurement Management Information System. A system developed by a procuring entity to track and manage the entire procurement process, from planning to contract completion. Definition 5. Procurement Register. A record maintained by each procuring entity to document all procurement activities. Definition 6. Administrative Sanction. Formal approval granted by a competent authority for incurring expenditure on a proposed project or procurement. Definition 7. Financial Sanction. Approval from the Finance Department or competent financial authority to allocate funds for a specific procurement. Definition 8. Technical Sanction. Approval from the relevant technical authority confirming that the proposed design, specifications, and cost estimates are technically sound and feasible. Definition 9. Appropriation. The allocation of funds by a legislative body for specific purposes. Definition 10. Reappropriation. The transfer of funds from one budget head to another. Definition 11. Beneficial owner. The natural person, S, who ultimately owns or controls a legal entity, even if through a chain of ownership or control.
6. Determination of need. In every case of a procurement, the procuring entity shall first determine the need and maintain documents relating to determination and assessment of need, in accordance with the provisions of Section 5(7) Procurement Plan. 1. A procurement plan shall be prepared by every procuring entity for each of the item of goods, works, or services to be procured during the year in accordance with Section 5. 2. The procurement plan shall specify the following: A. Nature of procurement goods/works/services. B. Major specifications, quantity/type/quality. C. Estimated value. D. Source of funds, state fund, central assistance, externally aided project, others. E. Budget code. F. Procurement method likely to be followed. G. Timeframe for bid process. And H. Timeframe for delivery of goods or services or completion of work, to identify the funds required in the next financial year or subsequent financial years. 3. The plan shall be based on inputs received for each item from officers at various hierarchical level of the procuring entity. 8. Numbering convention. Each procurement process undertaken by any procuring entity shall have a unique bid number, which shall be used for tracking purpose during and after the bid process. The unique bid number shall be designed like a code to reflect department, procuring entity, type of procurement, threshold value of procurement and method, year and serial number of bid in that particular year. 9. Procurement Management Information System and tracking. Every procuring entity shall develop and maintain a procurement management information system for tracking the procurement process, which shall include the following, namely: A. In order to track the performance of the procurement process, information shall be collated at the procuring entity level on quarterly basis and be available for reference at procuring entity level at all times, and shall be sent for collation to the respective administrative department. The administrative department shall further send the aggregated procurement management information to the State Procurement Facilitation Cell quarterly. B. The management information system shall cover the entire procurement cycle and incorporate performance targets set for various processes. C. The procurement management information system shall be developed in a query-based format to allow for in-depth analysis and ease of use, providing real-time information about the status of the bid at any point of time. This shall be integrated with the State Public Procurement Portal in order to further track performance on various parameters, including performance of contracts, delays, and penalties imposed. 10. Procurement register. Each procuring entity shall maintain a procurement register and ensure the safe custody of the procurement register. 11. Administrative, financial and technical sanctions and availability of budget provision. For each procurement, it shall be necessary to obtain all required approvals and sanctions as applicable. In case of procurement of works, this shall include administrative sanction, financial sanction, technical sanction, and appropriation or reappropriation. The procuring entity must have the necessary financial powers delegated to it for procurement of the subject matter. 12. Obligations related to value of procurement. The obligations related to value of procurement shall be as per the provisions of Section 813. Participation of bidders. 1. The procuring entity, at the time of inviting the participation of bidders in the procurement process, shall declare whether participation of bidders is limited or not, and if limited, grounds thereof. Such declaration may not ordinarily be altered later. 2. Normally the procedure of national competitive bidding, NCB, shall be adopted. The procedure of international competitive bidding, ICB, may be adopted if there is such a condition of adopting international competitive bidding for certain procurements under an obligation of an agreement with an intergovernmental international financing institution, or the subject matter of procurement is such that in the opinion of the procuring entity, it will be in the public interest to adopt international competitive bidding, after recording reasons. 1.3. Normally the procedure of international competitive bidding, ICB, for government bids up to Rs. 200 crores shall not be allowed. In case, international competitive bidding is to be adopted for government bids below Rs. 200 crores, then prior approval of the Finance Department shall be obtained. International competitive bidding may be adopted in government bids above Rs. 200 crores if the subject matter of procurement is such that in the opinion of the procuring entity, it will be in the public interest to adopt international competitive bidding, after recording reasons. 4. The bidders belonging to, or with beneficial ownership from countries sharing land border with India, for participation in any public procurement in the state, shall only be allowed after prior registration with the Industries Department of the Government of Rajasthan. 5. Notwithstanding anything contained in Subrule 2 and 3 above, as the case may be, the state government may by order in writing impose restrictions, including prior registration and/or screening, on procurement from bidders from a country or countries, or a class of countries, on grounds of defense of India, or matters directly or indirectly related thereto, including national security. To protect the essential security and strategic interest of India as specified in Clause D of subsection 4 of Section 6, no procurement shall be made in violation of such restrictions.
Definition. Agent, a person employed to act for another in dealings with third parties.
Explanation. For the purpose of this Rule 1, agent means a person employed to do any act for another or to represent another in dealings with third persons. 2. Beneficial owner means A. In case of a company or limited liability partnership, the beneficial owner is the natural person or persons who, whether acting alone or together, or through one or more juridical person, has a controlling ownership interest or who exercises control through other person. B. Controlling ownership interest is the ownership of, or entitlement to, more than 25% of shares or capital or profits of the company. C. Control shall include the right to appoint the majority of the directors or to control the management or policy decisions, including by virtue of their shareholding or management rights or shareholders' agreements or voting agreements. D. In case of a partnership firm, the beneficial owner is the natural person or persons who, whether acting alone or together, or through one or more juridical person, has ownership of entitlement to more than 15% of capital or profits of the partnership. E. In case of an unincorporated association or body of individuals, the beneficial owner is the natural person or persons who, whether acting alone or together, or through one or more juridical person, has ownership of or entitlement to more than 15% of the property or capital or profits of such association or body of individuals. F. Where no natural person is identified under subclause A, B, C, D or E above, the beneficial owner, is the relevant natural person who holds the position of senior managing official. G, in case of a trust, the identification of beneficial owner or owners shall include identification of the author of the trust, the trustee, the beneficiaries with 15% or more interest in the trust, and any other natural person exercising ultimate effective control over the trust through a chain of control or ownership. 3. Bidder from a country which shares a land border with India means A, an entity incorporated, established or registered in such a country. B, a subsidiary of an entity incorporated, established or registered in such a country. C, an entity substantially controlled through entities incorporated, established or registered in such a country. D, an entity whose beneficial owners situated in such a country. E, an Indian or other agent of such an entity. F, a natural person who is a citizen of such a country. G, a consortium or joint venture, where any member of the consortium or joint venture falls under any of the above. Chapter IV. Methods of procurement.
2 definitions. Definition 1. Bid security. A financial guarantee or instrument submitted by a bidder to ensure that they will fulfill the terms of their bid if selected. This can be in the form of cash, a bank guarantee, or a demand draft. Definition 2. Mutatis mutandis. A Latin phrase meaning, with the necessary changes having been made. It indicates that a provision applies with adjustments to fit the specific case.
14. Methods of procurement subject to the provisions of the Act, these rules, any additional conditions notified under Section 37, and guidelines issued under the Act. A procuring entity may procure a subject matter of procurement by any of the methods specified or notified under subsection 1 of Section 28. 15. Open competitive bidding procedure for procurement of a subject matter through open competitive bidding shall be as specified in Chapter V of these rules. 115A Swiss challenge method procedure for procurement of a subject matter through Swiss challenge method shall be as specified in Chapter VA of these rules. 16. Limited bidding. 1. In case of procurement of a subject matter as per Clause B of subsection 1 of Section 30. A procuring entity may adopt the method of limited bidding if the estimated cost or value of the subject matter is less than Rs. 2 lakh on one occasion, but it shall not exceed Rs. 10 lakh in a financial year. 3. Provided that a Panchayati Raj institution or its committee may adopt the method of limited bidding if the estimated cost or value of the subject matter is less than Rs. 6 lakh on one occasion, but it shall not exceed Rs. 60 lakh in a financial year. Provided further that procurement shall be made by the Panchayati Raj institution or its committee in accordance with the guidelines issued by the Rural Development and Panchayati Raj Department. 2. The procedure for limited bidding shall be as under. A. The procuring entity shall issue an invitation to bid by exhibiting it on the State Public Procurement Portal and by writing directly, and on the same day, to all the bidders who can supply the subject matter of procurement in terms of Clause A of subsection 1 of Section 30. Or Roman 2, all the bidders who are registered for the subject matter of procurement with the procuring entity, or where a procuring entity does not register the bidders in respect of a subject matter of procurement, to the registered bidders of any other procuring entity, if any. Or Roman 3, at least 3 manufacturers, authorized dealers, authorized service centers, bona fide dealers or service providers, in case registered bidders are not available. B. The procuring entity may allow all prospective bidders who fulfill the qualification criteria laid down for the procurement in the bidding documents, whether an invitation to bid has been issued to such bidders or not, to participate in the bidding process. C. A minimum period of 7 days. In case of emergency after recording reasons 3 days, shall be given to the bidders to offer their bids. D. If limited bidding is invited under Clause B and C of subsection 1 of Section 30, bid security shall not be obtained. E. For the remaining procedure of procurement by limited bidding, the provisions of Chapter V shall apply. Mutatis mutandis except publication of notice inviting bids in the newspapers as per Subrule 6 or 7 of Rule 43. 17. Single source procurement. 1. In addition to the conditions enumerated in subsection 1 of Section 31, A procuring entity may procure the subject matter by the method of single-source procurement. If A. Hiring of the services of consultant or professional is required, for a period up to 24 months and up to fina ensile limit of Rs 12 lakh in each case, subject to delegation of financial powers. 2. Provided that the above time period and financial limit shall not be applicable where services of retired government servant are required to be hired, then such services of retired government servant may be hired, and remuneration shall be paid at the rate as may be fixed by the Finance Department, Government of Rajasthan, from time to time. B. Price of subject matter of procurement is administered by the state government or the central government. 2. The procedure for single-source procurement shall be as under. 3. A. The procuring entity shall solicit a bid from the single prospective bidder, and shall also exhibit the invitation to bid on the state public procurement portal if the value of procurement is Rs 1 lakh or more. The procuring entity shall not exhibit the invitation to bid on the state public procurement portal, where 1. The services of a retired government servant are required under the proviso to Clause A of Subrule 1. Or 2. The procuring entity is of the opinion that subject matter for procurement is of nature specified in Clause E or H of subsection 1 of Section 31.
4 definitions. Definition 1. Reverse auction. A type of auction where the roles of buyer and seller are reversed. Multiple sellers compete to obtain business from a single buyer, and prices typically decrease as the sellers underbid each other. Definition 2. Performance security. A guarantee provided by the successful bidder to ensure satisfactory performance of the contract. It protects the procuring entity if the contractor fails to deliver. Definition 3. Pre-qualification. A preliminary screening process to assess the capabilities and eligibility of potential bidders before they are invited to submit full bids. Definition 4. Classified information. Information that a government or organization deems sensitive and needs to be protected from unauthorized disclosure.
However, in case where services of a retired government servant are hired, the work order shall be uploaded on the state public procurement portal. B. The procuring entity may engage in negotiations in good faith with the bidder. C. The single source may be selected out of the list of impaneled/registered bidders for the subject matter of procurement with the procuring entity or with any other procuring entity, where procuring entity uses the list of registered bidders of other procuring entity in terms of subsection 5 of Section 19 or suitable bidder identified through other reliable sources. D. Bid security shall not be obtained in case of single-source procurement. E. Except as otherwise provided in this rule and provisions of Chapter 5 relating to pre-qualification proceedings, bid security, publication of notice inviting bids in the newspapers, price of bidding documents, sale of bidding documents, pre-bid clarifications, exclusion of bids, comparison of rates of firms outside and those in Rajasthan, price purchase preference in evaluation and dividing quantities among more than one bidder at the time of award. All other provisions of Chapter 5 shall mutatis mutandis apply, but in case of matters covered under Subrule 1, performance security shall not be obtained. 3. Notwithstanding anything contained in Subrule 2, in the emergent situation arising out of floods and other natural calamities, the subject matter of procurement may be procured up to the ceiling rates. The committee consisting of the following shall decide the ceiling rates for subject matter of procurement on the basis of rates received during the last 6 months or the prevailing market rates analysis, namely, A. District Collector, Chairman, B. District Level Officer of the concerned department member, C. Treasury Officer, Member Secretary, D. Special Invitee, if required, Member 18. 2-stage bidding. The procedure for 2-stage bidding shall be as under. A. In the first stage of the bidding process, the procuring entity shall invite proposals containing the professional and technical competence, qualifications of bidders regarding the subject matter of procurement and contractual terms and conditions of the proposed procurement. B. All first-stage bids, which are otherwise eligible, shall be evaluated in accordance with the procedure laid down in these rules and the bidding documents by Bids Evaluation Committee. C. The committee may hold discussions with the bidders and if any such discussion is held, equal opportunity shall be given to all bidders to participate in the discussions. D. In revising the technical design, stipulations, relevant terms and conditions of the procurement, the procuring entity shall not modify the fundamental nature of the procurement itself, but may add, amend, or delete any specification of the subject matter of procurement or criterion for evaluation. E. Notwithstanding anything contained in sections 29 and 30, in the second stage of the bidding process, the procuring entity shall invite bids from all those bidders whose bids at the first stage were not rejected, to present final bid with bid prices and detailed technical bid in response to a revised set of terms and conditions of the procurement. F. Any bidder, invited to bid but not in a position to supply the subject matter of procurement due to changes in the specifications, may withdraw from the bidding proceedings without liability of forfeiting bid security. G. Except as otherwise provided in this rule, all other provisions of Chapter V shall, mutatis mutandis, apply. 19. Procedure of electronic reverse auction. 1. The procuring entity shall solicit bids by causing an invitation to the electronic reverse auction to be published in accordance with Rule 43. The invitation shall include a. The name and address of the procuring entity including email address if any. b. A detailed description of the subject matter of the procurement and the required time and location for providing such subject matter. c. The terms and conditions of the procurement contract, to the extent they are already known to the procuring entity, and the form of the contract, if any, to be signed by the parties. d. The criteria and procedures to be used for ascertaining the qualifications of bidders, and any documentary evidence or other information that must be presented by bidders to demonstrate their qualifications. E. The criteria and procedure for examining bids against the description of the subject matter of the procurement. F. The criteria and procedure for evaluating bids, including any mathematical formula that shall be used in the evaluation procedure during the auction. G. The manner in which the bid price is to be formulated and expressed, including a statement as to whether the price is to cover elements other than the cost of the subject matter of the procurement, such as any applicable transportation, insurance charges, customs duties, taxes, etc. H. The minimum number of bidders required to register for the auction. I. How the auction can be accessed. J. The deadline by which the bidders must register for the auction and the requirements for registration. K. The date and time of the opening of the auction and the requirements for identification of bidders at the opening of the auction. L. The criteria governing the closing of the auction. M. Other rules for the conduct of the auction, including the information that will be made available to the bidders in the course of the auction, the language in which it will be made available, and the conditions under which the bidders will be able to bid. N. References to the Act and these rules, and other laws and regulations directly pertaining to the procurement proceedings, including those applicable to procurement involving classified information, and the place where those laws and regulations may be found. O. The means by which the bidders may seek clarification of information relating to the procurement proceedings. P. The name, designation, and address of one or more officers or employees of the procuring entity including email address, if any, who are authorized to communicate directly with and to receive communications directly from the bidders in connection with the procurement proceedings before and after the auction without the intervention of an intermediary. Q. Verification of any formalities including, where applicable, ascertainment of qualifications or responsiveness before execution of a written procurement contract, and only after the fulfillment of such formalities, the contract shall come into force. And R. Any other requirement, which is considered by the procuring entity essential for the purpose. 2. The procuring entity may decide, in the light of the circumstances of the given procurement, that the electronic reverse auction shall be preceded by an examination or evaluation of initial bids. In such case, the invitation to the auction shall, in addition to information specified in Subrule 1 of this rule, include a. An invitation to present initial bids, together with instructions for preparing initial bids, and b. The manner, place, and deadline for presenting initial bids. 3. where the electronic reverse auction has been preceded by evaluation of initial bids, the procuring entity shall promptly after the completion of the evaluation of initial bids, A. Dispatch the notice of rejection, specifying the reasons for rejection to each bidder whose initial bid was rejected. B. Issue an invitation to the auction to each qualified bidder whose initial bid is responsive, providing all information required to participate in the auction. And C. Where an evaluation of initial bids has taken place, each invitation to the auction shall also be accompanied by the outcome of the evaluation, as relevant to the bidder to which the invitation is addressed. 20. Registration for the electronic reverse auction and the timing of holding the auction. 1. Confirmation of registration for the electronic reverse auction shall be communicated promptly to each registered bidder. 2. If the number of bidders registered for the electronic reverse auction is less than 3, to ensure effective competition, the procuring entity may cancel the auction. The cancellation of the auction shall be communicated promptly to each registered bidder. 3. The period of time between the issuance of the invitation to the electronic reverse auction and the auction shall be of minimum 7 days to bidders to prepare for the auction, taking into account the reasonable needs of the procuring entity. 21. Requirements during the electronic reverse auction. 1. The electronic reverse auction shall be based on a price, where the procurement contract is to be awarded to the lowest priced bid, or B. Price and other criteria specified to the bidders as applicable, where the procurement contract is to be awarded to the most advantageous bid. 2. During the auction. A. All bidders shall have an equal and continuous opportunity to present their bids. B. There shall be automatic evaluation of all bids in accordance with the criteria, procedure, and formula provided to the bidders. C. Each bidder must receive, instantaneously and on a continuous basis during the auction, sufficient information allowing it to determine the standing of its bid vis-a-vis other bids. And D. There shall be no communication between the procuring entity and the bidders or among the bidders, other than as provided for in clauses A and C above. 3. The procuring entity shall not disclose the identity of any bidder during the auction. 4. The auction shall be closed in accordance with the criteria specified to the bidders. 5. The procuring entity shall suspend or cancel the auction in the case of failures in its communication system that put at risk the proper conduct of the auction. The procuring entity may also cancel the procurement process under the provisions of Section 26. 22. Requirements after the electronic reverse auction. 1. At the closure of the electronic reverse auction, the lowest priced bid or the most advantageous bid, as the case may be, shall be the successful bid. 2. In procurement by means of an auction that was not preceded by examination or evaluation of initial bids, the procuring entity shall ascertain after the auction the responsiveness of the successful bid and the qualifications of the bidder submitting it. The procuring entity shall reject that bid if it is found to be unresponsive, or if the bidder submitting it is found unqualified. Without prejudice to the right of the procuring entity to cancel the procurement, the procuring entity may select the bid that was the next lowest priced or next most advantageous bid at the closure of the auction, if the bid is ascertained to be responsive and the bidder submitting it is ascertained to be qualified. 23. Other provisions for electronic reverse auction except as otherwise provided in Rule 19-22, the provisions of Chapter 5 shall, mutatis mutandis, apply to electronic reverse auction, except Rules 40, 49, 50, 52, 64, 68, and 69-24. Request for quotations. 1. A procuring entity may adopt the method of request for quotations for procurement if the estimated cost or value of the subject matter of procurement is less than Rs1 lakh on one occasion, but it shall not exceed Rs5 lakh in a financial year. 2. The procedure for request for quotations shall be as under. A. Quotations shall be requested from as many potential bidders as practicable, subject to a minimum of 3. B. Each bidder from whom a quotation is requested shall be informed whether any elements other than the charges for the subject matter of the procurement itself, such as any applicable transportation, insurance charges, customs duties, taxes, etc., are to be included in the price. C. Each bidder shall be permitted to give only one quotation. D. the successful quotation shall be the lowest priced quotation meeting the needs of the procuring entity as set out in the request for quotations. 25. Spot purchase. 1. A procuring entity may adopt the method of spot purchase for procurement if the estimated cost or value of the subject matter of procurement is less than Rs 50,000 on one occasion, but it shall not exceed Rs 3 lakh in a financial year. 2. A procuring entity shall procure a subject matter of procurement on the recommendation of the Spot Purchase Committee. The committee shall survey the market to ascertain the reasonableness of rate, quality, and specifications, and identify the appropriate supplier of the subject matter, and shall record the following certificate, certified that we. Names of members of the committee, members of the Spot Purchase Committee, are jointly and individually satisfied that the subject matter recommended for procurement is of the requisite specifications and quality, priced at the prevailing market rate, and the supplier recommended is reliable and competent to provide the subject matter in question. 26. Procurement without quotations. The subject matter of procurement valuing up to Rs 10,000 may be procured on one occasion subject to a limit of below Rs 1 lakh during a financial year without inviting quotations from the government departments/corporations, authorized dealers, cooperative stores, bandars, or retailers who are bona fide dealers in the subject matter of procurement. 27. Procurement of works by work order system and piecework system. 1. Works valuing less than Rs 1 lakh on each occasion may be procured, subject to a limit of Rs 5 lakh during a financial year, by work order system. Explanation. Work order system means method of procurement by giving order directly to a registered bidder to execute a work on scheduled rates in specified time. 2. The procedure for procurement through work order system shall be as under. A. In work order, the quantity, rate, and time of completion are invariably mentioned. Penalty for failure to complete the work within the stipulated time is also specified. Maximum work that can be allotted on a work order shall be less than Rs 1 lakh. B. Work order shall be given to a registered bidder only. C. Work order can be given only on the approved schedule of rates applicable to the division/subdivision concerned. The superintending engineer/executive engineer shall ensure that the rates being allowed on work order are not in excess of open bid rates prevalent in the area. D. Work order can be given by officers as per delegation of financial powers. And E. Work order agreement shall be executed after obtaining performance security in the form specified for the purpose. A register of work orders shall be maintained in the form specified for the purpose. 3. Works valuing below Rs 1 lakh on each occasion may be procured, subject to a limit of Rs 5 lakh during a financial year, by piecework system.
2 definitions. Definition 1. Empanelment. The process of creating a panel or list of qualified bidders for a particular category of goods, works, or services. Definition 2. Price fall clause. A provision in a rate contract ensuring that the price charged to the procuring entity will automatically decrease if the supplier offers a lower price to other customers during the contract period.
Explanation. Piecework system means method of procurement at the rates sanctioned by the competent authority without reference to the total quantity of work to be done within a given period. 4. The procedure for procurement through piecework system shall be as under. A. Execution of work on piecework system should normally be avoided. Piecework system may be resorted to only in a uniform type of work in large quantities, like earthwork of canals, desilting, repair and maintenance of roads, etc. B. For determination of rates, open bids shall be invited by additional chief engineer concerned for each division under its control. The intention of the department in inviting such bids for determination of annual rate contract for entering into piecework agreement should be made clear at the time of invitation of bids. Registered bidders of all categories shall be entitled to participate in such bids. After observing all required formalities of bids, the additional chief engineer shall sanction unit rates for the specified items of work, which shall remain in force normally for 1 year or until the rates are revised, but shall in no case remain in force more than 3 months after completion of 1 year. C. Once such unit rates have been sanctioned, divisional officers shall be competent to enter into piecework agreement below rupees 1 lakh at a time with a single registered bidder of any category. Second piecework agreement shall be entered into only after successful completion of the earlier work. Piecework agreement shall be entered into with the registered bidders allowed to operate in the said division. D. In the piecework system, the department is free to ask the bidders to cease the work, and payments are made for the work actually executed as per designs, drawings, specifications, after due measurements and checking of measurement as specified. The maximum period of completion of each piecework is 21 days, which shall not be extended in any case. E. In every divisional office, a register of piecework agreements shall be maintained in the forms specified for the purpose. In the first week of every month, the divisional officer shall submit copies of all piecework agreements accepted by him during the previous month to the superintending engineer, giving justification for the award of work on piecework agreement, explaining the necessity/emergency instead of on regular contracts. The superintending engineer, during his inspection and otherwise, shall ensure that the divisional officers do not execute work on piecework agreement in a routine manner and rates allowed are not in excess of the running rates approved by the additional chief engineer for the relevant division. And check with open bid rates of similar works on regular contract basis in the subdivision/division circle, and that the system of record measurements of work done and check measurements thereof is followed properly. F. The contract awarded on piecework system is exempted from depositing performance security. 28. Competitive negotiations. The procedure for competitive negotiation shall be as under. A. Procurement of the subject matter shall be made through the Competitive Negotiations Committee. The committee shall give the following certificate, certified that names of members of the committee. Members of the Competitive Negotiations Committee are jointly and individually satisfied that the subject matter of procurement recommended is of the requisite specifications and quality, priced at the prevailing market rate, and the supplier recommended is reliable and competent to supply the subject matter of procurement. B. To ensure effective competition, an adequate number, not being less than 3, of potential bidders selected in a non-discriminatory manner shall be included in procurement process. C. An equal opportunity shall be given to all bidders to participate in the negotiations. Any requirements, guidelines, documents, clarifications, or other information related to the negotiations that is communicated by the procuring entity to a bidder before or during the negotiations shall be communicated, subject to Section 49, at the same time, and on an equal basis to all other bidders engaging in negotiations with the procuring entity related to the procurement, unless such information is specific or exclusive to that bidder. D. After completion of negotiations, the procuring entity shall request all bidders remaining in the proceedings to present, by a specified time and date, a best and final offer with respect to all aspects of their proposals. E. The committee shall keep the record of all the bids received. F. No negotiations shall take place between the procuring entity and bidders with respect to their best and final offers. G. The procuring entity shall ensure that the successful offer is the lowest or most advantageous offer. And H. Nothing contained in Sections 5 to 10, both inclusive, Sections 12 to 27, both inclusive, and Chapter 3 of the Act shall apply to purchases made by competitive negotiations. 29. Rate contract. 1. In addition to the conditions included in subsection 1 of Section 36 for adopting the method of rate contract, a procuring entity may adopt the method of rate contract when it determines that by virtue of the nature of subject matter of procurement, the need for that subject matter may arise on an urgent basis during a given period of time. 2. The procedure for rate contract shall be as under. A procuring entity may award a rate contract by the method of open competitive bidding. If it is not possible to adopt the method of open competitive bidding, the procuring entity, after recording reasons, may adopt another method of procurement. An approximate quantity of required goods, works, or service during the period shall be indicated in the notice inviting bids, but no minimum quantity is guaranteed. B. The period of rate contract shall be generally 1 year, preferably a financial year to match with budget provisions and levy of taxes. It may be a shorter period if variations in market prices are expected to be significant. It may also be a longer period up to maximum 2 years if the variations in market prices are not expected to be significant. The reasons for selecting the period for rate contract shall be recorded. C. In the first stage single-part or two-part bids shall be invited in accordance with the provisions of Section 13. D. A rate contract shall be entered, for price without a commitment for quantity, place and time of supply of subject matter of procurement, with the bidder of lowest priced bid or most advantageous bid. E. In the second stage supply or work order shall be placed at the contracted price for supply or execution of the required quantity of the subject matter of procurement, mentioning the place of supply or execution, delivery schedule, etc., as and when needed. F. Rate contracts may be entered with more than one bidder, as parallel rate contracts provided there is such provision in the bidding documents, in the order of their standing in final evaluation, by giving them counter-offer of prices of the lowest or most advantageous bidder, in order to secure prompt delivery of goods or services or execution of works. If the quantity of the subject matter of procurement required is beyond the capacity of the lowest bidder or the subject matter of procurement is of critical or vital nature. G. The terms and conditions of the rate contract, including provision for liquidated damages, shall be similar to those prescribed for procurement by open competitive bidding. H. The prices under a rate contract shall be subject to price fall clause. A clause regarding price fall shall be incorporated in the terms and conditions of rate contract. Price fall clause is a price safety mechanism in rate contracts, and it provides that if the rate contract holder quotes reduces its price to render similar goods, works, or services at a price lower than the rate contract price to anyone in the state at any time during the currency of the rate contract, the rate contract price shall be automatically reduced with effect from the date of reducing or quoting lower price. For all delivery of the subject matter of procurement under that rate contract, and the rate contract shall be amended accordingly. The firms holding parallel rate contracts shall also be given opportunity to reduce their price by notifying them the reduced price, giving them 15 days' time to intimate their acceptance to the revised price. Similarly, if a parallel rate contract holding firm reduces its price during currency of the rate contract, its reduced price shall be conveyed to other parallel rate contract holding firms and the original rate contract holding firm for corresponding reduction in their prices. If any rate contract holding firm does not agree to the reduced price, further transaction with it shall not be conducted. I. It should be ensured that new rate contracts become operative right after the expiry of the existing rate contracts without any gap. In case it is not possible to conclude the new rate contracts due to unavoidable reasons, the existing rate contracts may be extended on same price, terms, and conditions for a period not exceeding 3 months. In such cases, it shall be ensured that market prices have not fallen down during the period for the subject matter of procurement or its constituents, to be procured under the rate contract. J. Except as otherwise provided in this rule, all other provisions of Chapter 5 shall, mutatis mutandis, apply. 30. Registration. The registration of the bidders shall be carried out in the manner and in accordance with the rules made in this behalf by the state government. 31. Empanelment by prequalification process. 1. The procuring entity may prepare a panel of bidders for the subject matter of procurement that is required frequently, but the details of the subject matter, its quantity, time, and place is not known in advance. This list shall be valid for 1 year, which may further be extended for another 1 year after recording reasons. The procuring entity may prepare separate panel for different subject matter of procurement. 2. The provisions relating to pre-qualification of bidders under Section 18 and publicity, as per Subrule 6 or 7 of Rule 43, shall apply to empanelment proceedings. 3. The procuring entity shall invite applications for empanelment for pre-qualification, as per the procedure prescribed for inviting open competitive bidding. 4. The invitation for empanelment shall also include the following information. A. The name and address of the procuring entity. B. Eligibility criteria required for empanelment. C. The terms and conditions of the empanelment, including the duration of the empanelment. And D. The description of the subject matter of procurement, to the extent known. 5. The procurement of subject matter shall be done by the procuring entity from amongst the empaneled bidders up to the limit of delegation of financial powers, by sending to all of them request for proposals with financial bid. 32. Direct procurement from notified agencies. A procuring entity may procure subject matter of procurement from the category of bidders, without inviting bids, as notified by the state government, from time to time. 33. Purchase or price preference in procurement. A procuring entity shall provide price preference or purchase preference in procurement to the category of bidders as notified by the state government, from time to time. Chapter V. Bid process, management. Open competitive bidding.
3 definitions. Definition 1. Notice inviting bids, NIB. A formal announcement by a procuring entity inviting potential bidders to participate in a procurement process. Definition 2. Concession agreement. A contract that gives a private company the right to operate a specific business within the government's jurisdiction, subject to certain terms. Definition 3. Discounted cash flow techniques. Methods used to estimate the value of an investment based on its expected future cash flows, adjusted for the time value of money.
34. Description of subject matter of procurement. 1. The description of the subject matter of procurement shall be set out in the pre-qualification documents, bidder registration documents, or the bidding documents as provided in Section 12. 2. In description of the subject matter of the procurement, the procuring entity shall, if required, include specifications, plans, drawings, designs, trials, sample testing and test methods, packaging, marking, labeling, conformity certification, or symbols and terminology. 35. Criteria for evaluation of bids. In addition to the criteria for evaluation set out in Section 14, the evaluation criteria, where relevant, may include the discounted cash flow techniques. 36. Preparation of bidding documents. 1. Before issuing a notice inviting bids, the procuring entity shall ensure that the bidding documents are ready for sale. 2. The bidding documents shall have the following sections, namely: A. Notice inviting bids NIB. B. Instruction to bidders ITB. C. Bid data sheet BDS. D. Qualification and evaluation criteria. E. Bidding forms. And F. Conditions of contract and contract forms. 1. General conditions of contract. 2. Special conditions of contract. And 3. Contract forms. G. Any other documents as may be necessary. 3. The bidding documents shall include the following, namely: A. Instructions for preparing bids. B. The criteria and procedures that shall be applied in the ascertainment of the qualifications of bidders. C. The requirements as to documentary evidence or other information that must be submitted by bidder in proof of its qualifications. D. A detailed description of the subject matter of the procurement, including but not limited to technical specifications, plans, drawings and designs if relevant, the quantity of the goods, any incidental services to be performed, the location where the goods are to be delivered, the work is to be executed or the services are to be provided, and the required time, if any. E. The detailed procedure for presentation, opening, examination, and evaluation of bids, minimum requirement, if any, with respect to technical, quality, and performance characteristics that bids must meet in order to be considered responsive, and the criteria to be used by the procuring entity in evaluation of bids and determining the successful bid, including any provision for preference and any criteria other than price to be used and the relative weight of such criteria. F. The terms and conditions of the procurement contract or the rate contract, to the extent they are already known to the procuring entity, and the contract or agreement form, if any, to be signed by the parties. FF. A condition which allows only one subcontract subletting, without any prior approval of the procuring entity, to curated score startups, by the contractor-approved bidder up to the limit as mentioned below, subject to maximum of 20% of the original contract value. G. If alternatives to the characteristics of the goods, works, or services, contractual terms and conditions, or other requirements set forth in the bidding documents are permitted. a statement to that effect, and a description of the manner in which alternative bids are to be evaluated and compared. H. If bidders are permitted to submit bids for only a portion of the goods, works, or services to be procured, a description of the portion or portions for which bids may be submitted. I. The manner in which the bid price is to be formulated and expressed, including a statement as to whether the price is to cover elements other than the cost of the goods, works, or services themselves, such as any applicable transportation and insurance charges, customs duties and taxes, etc. J. Any requirements of the procuring entity with respect to the issuer and the nature, form, amount, and other terms and conditions of any bid security to be provided by bidder submitting bid, and any such requirements for any security for the performance of the procurement contract or the rate contract to be provided by the bidder that enters into the procurement contract, including securities such as labor and materials bonds. K. The manner, place, and deadline for the submission of bids. L. The means by which bidders may seek clarifications of the bidding documents and a statement as to whether the procuring entity intends to convene a meeting of bidders. M. The period of time during which bids shall remain valid. N. The place, time, and date for the opening of bids. O. References to the Act. These rules and other laws and regulations directly pertinent to the procurement proceedings, provided, however, that the omission of any such reference shall not constitute grounds for appeal or liability on the part of the procuring entity. P. The name, designation, address, and email address, if any, of one or more officers or employees of the procuring entity who are authorized to communicate directly with and to receive communications directly from bidders in connection with the procurement proceedings, without the intervention of an intermediary. Q. Any commitments to be made by the bidder outside of the procurement contract, such as commitments relating to the transfer of technology. R. Reference to the right provided to seek appeal of an unlawful act or decision of, or procedure followed by the procuring entity in relation to the procurement proceedings. S. If the procuring entity reserves the right to cancel bid proceedings and reject all bids, a statement to that effect. T. Any formalities that shall be required once a bid has been accepted for a procurement contract or rate contract to enter into force, including, where applicable, the execution of a written procurement contract and approval by a higher authority or the state government. And U. Any other requirements laid down by the procuring entity like detailed project report, concession agreement, design, plans, etc. in conformity with the Act and these rules relating to the preparation and submission of bids, and to other aspects of the procurement proceedings. 4. The procuring entity shall provide the bidding documents to each bidder that responds to the invitation to bids in accordance with the procedures and requirements specified therein. If pre-qualification, empanelment, or registration proceedings have been engaged in, the procuring entity shall provide a set of bidding documents to each bidder that has been pre-qualified, and that pays the price, if any, charged for that document.
Table summary. The maximum subcontract value for curated score startups varies from bronze to platinum signature, with platinum signature startups having the highest limit and bronze startups having the lowest.
37. Single-part and two-part bids. A procuring entity may choose to invite bids in one part or two parts, as per the provisions of Section 13. 38. Qualification of bidders. In addition to the provisions regarding qualification of bidders, as set out in Section 7. A. The procuring entity shall disqualify a bidder if it finds at any time that 1. The information submitted concerning the qualifications of the bidder was false or constituted a misrepresentation, or 2. The information submitted concerning the qualifications of the bidder was materially inaccurate or incomplete. And B. The procuring entity may require a bidder, who was pre-qualified, to demonstrate its qualifications again in accordance with the same criteria used to pre-qualify such bidder. The procuring entity shall disqualify any bidder that fails to demonstrate its qualifications again, if requested to do so. The procuring entity shall promptly notify each bidder requested to demonstrate its qualifications again as to whether or not the bidder has done so to the satisfaction of the procuring entity. 39. Eligibility of bidders. 1. A bidder may be a natural person, private entity, government-owned entity, or, where permitted in the bidding documents, any combination of them with a formal intent to enter into an agreement or under an existing agreement in the form of a joint venture. In the case of a joint venture, A. All parties to the joint venture shall sign the bid, and they shall be jointly and severally liable. And B. A joint venture shall nominate a representative who shall have the authority to conduct all business for and on behalf of any or all the parties of the joint venture during the bidding process. In the event the bid of joint venture is accepted, either they shall form a registered joint venture company firm, or otherwise all the parties to joint venture shall sign the agreement. 2. A bidder should not have a conflict of interest in the procurement in question, as stated in Rule 81 and the bidding documents. The procuring entity shall take appropriate actions against the bidder in accordance with Section 11 and Chapter IV of the Act, if it determines that a conflict of interest has flawed the integrity of any procurement process. All bidders found to have a conflict of interest shall be disqualified. 3. A bidder debarred under Section 46 shall not be eligible to participate in any procurement process undertaken by A. Any procuring entity, if debarred by the state government, and B. A procuring entity if debarred by such procuring entity. 4. In case of procurement of goods, bidder must be a manufacturer, distributor, or bona fide dealer in the goods, and it shall furnish necessary proof for the same in the specified format. Where applicable, proof of authorization by the manufacturer or country distributor in India shall be enclosed. 1 Rule 40. Time frame for the procurement process. 1. The time frame for the one-stage bidding shall be as under table. Bid cycle of outer time frame for various procurement method by one-stage bidding, provided that, in appropriate cases, the procuring entity may, with the approval of the competent authority authorized by the state government for the purpose, relax the above-mentioned time frame of bid process. 2. A decision on acceptance or rejection of bids invited in a procurement process must be taken by the competent sanctioning authority within the period as given below, even if the period of validity may be more, from the date of opening of technical bids where two-envelope system is followed, otherwise from the date of opening of financial bids. If the decision is not taken within the given time period by the concerned sanctioning authority, reasons of not taking decision within the given time period shall be specifically recorded by the competent sanctioning authority while taking its decision.
5 definitions. Definition 1. Bank guarantee. A promise from a bank to cover losses if a bidder fails to meet its obligations. It's used to ensure financial security in procurement processes. Definition 2. Bid securing declaration. A written commitment by a bidder to avoid certain actions, like withdrawing a bid that could harm the procurement process. It's used instead of bid security in some cases. Definition 3. Scheduled bank. Banks included in the second schedule of the Reserve Bank of India Act, 1934. These banks meet specific criteria and are considered financially sound. Definition 4. Addendum. A formal change or addition to the bidding documents issued by the procuring entity after the initial release. Definition 5. Insurance surety bonds. Financial guarantees provided by insurance companies that ensure the fulfillment of contractual obligations by the bidder. They act as a substitute for traditional bid and performance securities.
Rule 41. Pre-qualification proceedings. In addition to the provisions of Section 18, the procedure of pre-qualification process shall be carried out in the manner as specified below. A. Registration or emplacement of prospective bidders may be done as per the procedure specified for pre-qualification proceedings. B. The procuring entity shall take a decision to pre-qualify a bidder only in accordance with the criteria and procedures S set out in the invitation to pre-qualify and in the pre-qualification documents. C. The procuring entity shall promptly notify each bidder presenting an application to pre-qualify whether or not it has been pre-qualified, and also publish the result of pre-qualification proceedings on the State Public Procurement Portal. D. The procuring entity shall promptly communicate with reasons to each bidder that it has not been pre-qualified. 42. Bid security. 1. Bid security shall not be taken in case of petty procurement valuing up to Rs 10,000 and procurement by the methods of limited bidding under Clause B and C of subsection 1 of Section 30, request for quotations, spot purchase, single source procurement, and competitive negotiations. 2. In case of open competitive bidding, two-stage bidding, rate contract, electronic reverse auction, bid security shall be 2% or as specified by the state government of the estimated value of subject matter of procurement put to bid. In case of 5 micro, small and medium enterprises, of Rajasthan it shall be 0.5% of the quantity 6 offered for supply or service to be rendered, and in case of SIC industries, other than 5 micro, small and medium enterprises, whose cases are pending with Board of Industrial and Financial Reconstruction, it shall be 1% of the value of bid. Concessional bid security may be taken from registered bidders as specified by the state government. Every bidder, if not exempted, participating in the procurement process shall be required to furnish the bid security as specified in the notice inviting bids to. 3. Provided that, during the period commencing from the date of commencement of the Rajasthan Transparency in Public Procurement, Second Amendment, Rules, 2020 to 31/12/2021, in lieu of bid security, a bid security declaration shall be taken. 1.3. In lieu of bid security, a bid securing declaration shall be taken from the 1 department's boards of the state government or central government. 2. Government companies as defined in Clause 45 of Section 2 of the Companies Act, 2013. 3. Company owned or controlled, directly or indirectly, by the central government, or by any state government or governments, or partly by the central government and partly by one or more state governments, which is subject to audit by the auditor appointed by the Comptroller and Auditor General of India under subsection 5 or 7 of Section 139 of the Companies Act, 2013. 4. Autonomous bodies, registered societies, cooperative societies, which are owned or controlled or managed by the state government or central government. Or 4. 5. Bidder in procurement related to Panchayat Samiti Nandishala January Sabhajita Yajana or Gram Panchayat Gashala / Pashu Asharya Esthal January Sabhajita Yajana issued by the state government. 4. Bid security instrument or cash receipt of bid security or a bid securing declaration shall necessarily accompany the sealed bid. 5. Bid security of a bidder lying with the procuring entity in respect of other bids awaiting decision shall not be adjusted towards bid security for the fresh bids. The bid security originally deposited may, however, be taken into consideration in case bids are re-invited. 6. The bid security may be given in the form of cash, a banker's check or demand draft, or bank guarantee or electronic bank guarantee (EBG), in specified format, of a scheduled bank or insurance surety bonds issued by insurer registered with the Insurance Regulatory and Development Authority of India, IRDA, for transact the business of issuing insurance surety bonds, or deposit through EGRAS. The bid security must remain valid 30 days beyond the original or extended validity period of the bid. 7. The bidding documents may stipulate that the issuer of the bid security and the confirmer, if any, or the bid security, as well as the form and terms of the bid security, must be acceptable to the procuring entity. In cases of international competitive bidding, the bidding documents may in addition stipulate that the bid security shall be issued by an issuer in India. 8. Prior to presenting a submission, a bidder may request the procuring entity to confirm the acceptability of proposed issuer of a bid security or of a proposed confirmer, if required. The procuring entity shall respond promptly to such a request. 9. The bank guarantee or electronic bank guarantee, EBG, presented as bid security shall be got confirmed from the concerned issuing bank. However, the confirmation of the acceptability of a proposed issuer or of any proposed confirmer does not preclude the procuring entity from rejecting the bid security on the ground that the issuer or the confirmer, as the case may be, has become insolvent or has otherwise ceased to be creditworthy. 10. The bid security of unsuccessful bidders shall be refunded soon after final acceptance of successful bid and signing of agreement and submitting performance security. 11. The bid security taken from a bidder shall be forfeited in the following cases, namely: A. When the bidder withdraws or modifies its bid after opening of bids. B. When the bidder does not execute the agreement, if any, after placement of supply/work order within the specified period. C. When the bidder fails to commence the supply of the goods or service or execute work as per supply/work order within the time specified. D. When the bidder does not deposit the performance security within specified period after the supply/work order is placed. And E. If the bidder breaches any provision of Code of Integrity prescribed for bidders specified in the Act and Chapter VI of these rules. 12. In case of the successful bidder, the amount of bid security may be adjusted in arriving at the amount of the performance security, or refunded if the successful bidder furnishes the full amount of performance security. 13. The procuring entity shall promptly return the bid security after the earliest of the following events, namely: A. The expiry of validity of bid security. B. The execution of agreement for procurement and performance security is furnished by the successful bidder. C. The cancellation of the procurement process. Or D. The withdrawal of bid prior to the deadline for presenting bids, unless the bidding documents stipulate that no such withdrawal is permitted. 43. Notice inviting bids. 1. A procuring entity shall solicit bids in open competitive bidding and two-stage bidding, or, where applicable, applications for prequalification by causing an invitation to bid or prequalify, as the case may be, to be published on the State Public Procurement Portal and on its own official website if available. An abridged notice shall also be published in newspapers of adequate circulation, as prescribed in Sub-Rule 6 and 7 of this rule. 2. An invitation to bid to be published on the State Public Procurement Portal shall contain, at least, the following information, namely: A. The name and address of the procuring entity including email address, if any. B. A summary of the principal required terms and conditions of the procurement contract or rate contract to be entered into as a result of the procurement proceedings, including the nature, quantity, time and place of delivery of the goods to be supplied, the works to be executed, or the services to be provided. E. Whether the bid procedure shall be conducted in a single stage or two stages, and whether it is to be presented simultaneously in two envelopes, one envelope containing the technical, quality and performance characteristics of the bid, and the other envelope containing the financial aspects of the bid. D. The criteria and procedures to be used for evaluating the qualifications of bidders. E. The procedure of obtaining the solicitation documents and the place from which they may be obtained. F. The price, if any, charged by the procuring entity and the mode of payment for the solicitation documents and the amount of bid security and its form. G. The manner, place and deadline for the submission of bids. H. Right of the procuring entity to cancel the bid process and reject any or all of the bids. I. The time, date, and place of opening of bids. J. Whether any of the items of procurement are reserved for a specific category of bidders. And K. Any other important information. 3. An invitation to prequalify to be published on the State Public Procurement Portal shall contain, at least, the following information, namely: A. The name and address of the procuring entity including email address, if any. B. A summary of the required principal terms and conditions, to the extent known at the time of invitation to prequalify, of the procurement contract or rate contract to be entered into as a result of the procurement proceedings, including the nature, quantity and place of delivery of the goods to be supplied, the nature and location of the works to be effected, or the nature of the services and the location where they are to be provided, as well as the required time for the supply of the goods or for the completion of the works, or the timetable for the provision of the services, if already known. C. The criteria and procedures to be followed for evaluating the qualifications of bidders. D. The procedure of obtaining the pre-qualification documents and the place from which they may be obtained. E. The price, if any, charged by the procuring entity and the mode of payment for the prequalification documents and subsequent to prequalification for the bidding documents. F. The manner, place and deadline for presenting applications to prequalify. And G. The time, date and place of opening of proposals for prequalification. 4. Deleted. 5. The notice inviting bids to be published in the newspapers must be in brief. The bids for more than one subject matter of procurement shall be published in one notice, as far as possible. 2.6. Time for submission of bids for supply of goods or providing services in response to publication of notice inviting bids in newspapers and notice boards shall be as under. Provided that, in appropriate cases, the procuring entity may relax the above-mentioned period of publication of notice inviting bid and submission of bid if the estimated value of procurement is up to Rs. 50 crores and with the approval of the administrative department concerned if the value of procurement is more than Rs. 50 crores. 6. Time for submission of bids for supply of goods or providing services in response to publication of notice inviting bids in newspapers and notice boards shall be as under. I. 7. Time for submission of bids for execution of works in response to publication of notice inviting bids in newspapers and notice boards shall be as under, provided that, in appropriate cases, the procuring entity may relax the above-mentioned period of publication of notice inviting bid and submission of bid if the estimated value of procurement is up to Rs. 50 crores and with the approval of the administrative department concerned if the value of procurement is more than Rs. 50 crores. Provided that, in appropriate cases, the procuring entity may, with the approval of the competent authority authorized by the state government for the purpose, relax the above-mentioned period of publication of notice inviting bid and submission of bid. / substituted words, English daily newspaper, by notification no. F. 1-8, FD/GF and R/2011 dated 4/9/2013, published in Raj. Gazette EO-PT 4 GA, I dated 4/9/2013, PT 4 GA, I dated 4/9/2013. 8. In case of international competitive bidding in which the bid notice is to be addressed to international bidders, the notice inviting bids shall additionally be published by using suitable mediums that attract international responses. This may include circulation of notice inviting bids to the Indian embassies abroad, foreign embassies in India, international trade journals, etc. Period for submission of bid from the date of first publication of notice inviting bid shall be 45 days. 9. The notice inviting bids shall be published by the government departments in newspapers through Information and Public Relations Department, Rajasthan, with a request in which category of newspapers such notice is to be published. 10. Deleted. 11. The procuring entity shall have right to cancel the bid process and reject any or all of the bids. 44. Price for bidding documents, pre-qualification documents or bidder registration documents and processing fee or user charges the price for the bidding documents, pre-qualification documents or registration documents shall be fixed after considering its preparation and delivering costs. The procuring entity may also charge processing fee or user charges for using e-procurement facility. 45. Sale of bidding documents. 1. The sale of bidding documents shall be commenced from the date of publication of notice inviting bids and shall be stopped 1 day prior to the date of opening of bids. The complete bidding documents shall also be placed on the state public procurement portal. The prospective bidders shall be permitted to download the bidding document from the website and pay its price while submitting the filled-up bidding document to the procuring entity or e-procurement gateway, if the facility is available. 2. The bidding documents, pre-qualification documents or bidder registration documents shall be made available to any bidder who pays the price for it in cash or by bank demand draft, banker's check, unless the procurement is reserved for specific category of bidders. Provided that in case pre-qualification proceedings were held for a bidding process, including registration or empanelment proceedings, the bidding documents shall be made available to only those bidders who have been pre-qualified or registered or empaneled, as the case may be. 3. A detailed account of bidding documents sold shall be kept. It shall also incorporate the details of the bidding documents downloaded from the website when their price is paid at the time of submission of bid. 4. Bidding documents purchased by principal of any concern may be used by its authorized sole-selling agents marketing, agents, distributors, sub-distributors, and authorized dealers, or vice versa. 46. Pre-bid clarification subject to the provisions contained in Section 22, the procuring entity may convene a pre-bid conference of the bidders, and shall prepare minutes of the meeting containing the requests submitted at the meeting for clarification of the bidding documents and its responses to those requests, without identifying the person who made the requests. The minutes and response under subsection 3 of Section 22, if any, shall be provided promptly to all bidders to which the procuring entity provided the bidding documents, so as to enable those bidders to take the minutes into account in preparing their bids, and shall be published on the State Public Procurement Portal. 47. Changes in the bidding documents at any time prior to the deadline for presenting bids, the procuring entity may for any reason, whether on its own initiative or as a result of a request for clarification by a bidder, modify the bidding documents by issuing an addendum in accordance with provisions of Section 23. 48. Period of validity of bids. 1. Bids submitted by the bidders shall remain valid during the period specified in the bidding documents. This period should normally be not more than 90 days, but depending on the nature of the procurement it may be more. A bid valid for a shorter period shall be rejected by the procuring entity as non-responsive. 2. Prior to the expiry of the period of validity of bids, the procuring entity, in exceptional circumstances, may request the bidders to extend the bid validity period for an additional specified period of time. A bidder may refuse the request, and such refusal shall be treated as withdrawal of bid, but in such circumstances, bid security shall not be forfeited. 3. Bidders that agree to an extension of the period of validity of their bids shall extend or get extended the period of validity of bid securities submitted by them, or submit new bid securities to cover the extended period of validity of their bids. A bidder whose bid security is not extended, or that has not submitted a new bid security, is considered to have refused the request to extend the period of validity of its bid. 49. Format and signing of bids. 1. The bidder shall prepare one original set of the bidding documents called bid and clearly mark it as original, and if asked, the bidder shall submit additional copies of the bid in such number as specified in the bidding documents and clearly mark them as copy. In the event of any discrepancy between the original bid and its copies, the contents of the original bid shall prevail. 2. The original and all copies of the bid shall be typed or written in ink, and all the pages shall be signed by the bidder or a person duly authorized to sign on behalf of the bidder, in token of acceptance of all the terms and conditions of the bidding documents. This authorization shall consist of a written confirmation as specified in the bidding documents and shall be attached to the bid. 3. Any corrections in the bid such as interlineations, erasures, or overwriting shall be valid only if they are signed or initialed by the person signing the bid. 4. Similar procedure for signing of bids shall be adopted for technical and financial bids if two-part bids have been invited. 50. Sealing and marking of bids. 1. Bidders may submit their bids by post or by hand, but if so specified in the bidding documents, bidders shall submit their bids only electronically. Bidders submitting bids electronically shall follow the electronic bid submission procedure as specified on the State Public Procurement Portal. 2. Bids submitted by post or by hand shall enclose the original and each copy of the bid in separate sealed envelopes, duly marked envelopes as original and copy. The envelopes containing the original and the copies shall then be enclosed in one single envelope. 3. The inner and outer envelopes shall a. Bear the name and complete address along with telephone mobile number of bidder. B. Bear complete address of the procuring entity with telephone number, if any. C. Bear the specific identification of the bidding process pursuant to notice inviting bids, and any additional identification marks as specified in the bidding documents. And D. Bear a warning not to be opened before the time and date for bid opening, in accordance with the notice inviting bids. 4. If all envelopes are not sealed and marked as required, the procuring entity shall assume no responsibility about its consequences. 5. Similar procedure for sealing and marking of bids shall be adopted for technical and financial bids if two-part bids have been invited. 51. Deadline for the submission of bids. 1. Bids shall be received by the person designated for the purpose by the procuring entity or directly dropped in the bid box, at the place and up to the time and date specified in the notice inviting bids. 2. Normally, the date of submission and opening of bids should not be extended. In exceptional circumstances, or when the bidding documents are required to be substantially modified as a result of discussions in pre-bid conference or otherwise, and the time with the prospective bidders for preparation of bids appears insufficient, the date may be extended by the procuring entity. In such case, the publicity of extended time and date shall be given in the manner, as was given at the time of issuing the original notice inviting bids, and shall also be placed on the State Public Procurement Portal. It should be ensured that after issue of corrigendum, reasonable time is available to the bidders for preparation and submission of their bids. The procuring entity shall also publish such modifications in the bidding documents in the same manner as the publication of initial bidding documents. If in the office of the bids receiving and opening authority, the last date of submission or opening of bids is a non-working day, the bids shall be received or opened on the next working day. 52. Late bids. The person authorized to receive the bids shall not receive any bid that is submitted personally, after the time and date fixed for submission of bids. Any bid which arrives by post after the deadline for submission of bids shall be declared and marked as late and returned unopened to the bidder by registered post. 53. Receipt and custody of bids. 1. The bids shall be received by hand delivery, by courier or by post in the specified format up to the specified time and date, and at the specified place, by the person authorized by the procuring entity, except when bids are received through e-procurement or they are directly dropped in the bid box. 2. The person authorized to receive the bids shall provide a receipt signed by him with date and time of receipt of bid to the person who delivers the bid. 3. All bids received unsealed, in torn or damaged condition through post or by personal delivery, shall be so marked and signed on the cover by the person receiving the same, and get signed on it by the person delivering it, and put in a fresh cover and reseal, if so warranted. All such entries shall be attested by the receiving person. 4. Preferably, all bids received shall be put into a duly locked bid box placed for receiving the bids. In the absence of a bid box, the received bids shall be kept in safe custody in lock and key by the person authorized to receive the bids. 5. The location of bid box shall be such as to facilitate easy access to bidders. The bid box shall have 2 sealed locks. The key of one of the locks shall remain with the procuring entity, and the key of the other lock shall be with the person authorized to receive the bids. 6. Bids received by the authorized person on or before the time and date fixed for receipt of bids shall be entered in bids receipt register, and the same shall be closed at the scheduled time and date, giving in words and figures the number of bids received up to the last time and date for submission of bids. 7. The record of bids received late through post shall be entered in bids receipt register after closing the register as per subrule 6. 8. Bids received by telegram or given on form other than the prescribed form shall not be considered. 9. In case of e-tendering, that is to say bid proposals submitted through electronic methods, the same shall be submitted in accordance with the procedure outlined on the State Public Procurement Portal.
The table outlines the time frame for different stages of procurement using open competitive bidding versus limited bidding and single source procurement. The issue of bidding documents occurs on the day of the first publication of notice inviting bids for open competitive bidding. The submission of bids varies based on the estimated value of procurement and whether clarifications or addenda are issued. For limited bidding and single source procurement, the submission of bids is 7 days from the issue of bidding documents or the date of issue of clarifications or addenda. Table summary. The time allowed for decision varies depending on the authority competent to take the decision, ranging from 4 days for the additional chief engineer to 70 days for the Finance Committee Board, Empowered Committee, Empowered Board, etc. Table summary. The time frame is the same for both normal and special circumstances for technical bid opening, issue of letter of award, execution of contract agreement, and declaration of the bid results. Table summary. The time allowed for bid decisions varies depending on the authority, ranging from 20 days for the head of office or executive engineer to 50 days for the administrative department concerned. Table summary. The time for bid submission increases with the estimated value of procurement, and the mode of publication becomes more extensive as the value increases. Table summary. The table specifies the time for bid submission and publication modes based on the estimated procurement value. Higher value procurement requires longer submission times and broader publication reach. Table summary. The time for bid submission and modes of publicity for work procurement depend on the estimated value of the work. The higher the value, the longer the submission period, and the wider the publication reach. Table summary. The table specifies timelines for bid submissions and publicity modes based on estimated procurement value. Timelines increase and publicity expands from notice boards to regional, state, and all India newspapers as the value rises.
54. Withdrawal, substitution, and modification of bids. 1. A bidder may withdraw, substitute, or modify its bid after it has been submitted by sending a written notice, duly signed by him or his authorized representative, authorization letter be enclosed. Corresponding substitution or modification of the bid must accompany the written notice. The notice must be A. submitted in accordance with the bidding documents, and in addition, the envelope shall be clearly marked as withdrawal, substitution, or modification, and B. received by the person authorized to receive the bids or directly dropped in the bid box prior to the last time and date fixed for receiving of bids. 2. Bids requested to be withdrawn shall be returned unopened to the bidders. 3. No bid shall be withdrawn, substituted, or modified after the last time and date fixed for receipt of bids. 55. Opening of bids. 1. The sealed bid box shall be opened by the bid opening committee constituted by the procuring entity at the time, date and place specified in the bidding documents in the presence of the bidders or their authorized representatives, who choose to be present. 2. The bid's receiving person shall also hand over all the bids received by him up to the time and date for submission of bids to the convener of bids opening committee and obtain its signature in the bids receipt register. 3. The bid opening committee may co-opt experienced persons in the committee to conduct the process of bid opening. 4. If electronic bidding is adopted, specific electronic bid opening procedure, as specified on the State Public Procurement Portal, shall be followed. The bidders may witness the electronic bid opening procedure online. 5. The bids shall be opened by the bids opening committee in the presence of the bidders or their authorized representatives who choose to be present. All envelopes containing bids shall be signed with date by the members of the committee in token of verification of the fact that they are sealed. The envelopes shall be numbered as a N, where A denotes the serial number at which the bid envelope has been taken for opening, and N denotes the total number of bids received by specified time. 6. The bid opening committee shall prepare a list of the bidders or their representatives attending the opening of bids and obtain their signatures on the same. The list shall also contain the representative's name and telephone number and corresponding bidders' names and addresses. The authority letters brought by the representatives shall be attached to the list. The list shall be signed by all the members of bid opening committee with date and time of opening of the bids. 7. First, envelopes marked as withdrawal shall be opened, read out, and recorded, and the envelope containing the corresponding bid shall not be opened, but returned to the bidders. No bid shall be permitted to be withdrawn unless the corresponding withdrawal notice contains a valid authorization to request the withdrawal and read out and recorded in bid opening. If the withdrawal notice is not accompanied by the valid authorization, the withdrawal shall not be permitted, and the corresponding bid shall be opened. Next, envelopes marked as substitution shall be opened, read out, recorded and exchanged for the corresponding bid being substituted, and the substituted bid shall not be opened, but returned to the bidder. No bid shall be substituted unless the corresponding substitution notice contains a valid authorization to request the substitution and is read out and recorded at bid opening. Envelopes marked as modification shall be opened thereafter, read out and recorded with the corresponding bid. No bid shall be modified unless the corresponding modification notice contains a valid authorization to request the modification and is read out and recorded at bid opening. Only envelopes that are opened, read out, and recorded at bid opening shall be considered further. 8. All other envelopes shall be opened one at a time, and the following details shall be read out and recorded: A. The name of the bidder, and whether there is a substitution or modification. B. The bid prices per lot if applicable. C. The bid security if required. and D, any other details as the committee may consider appropriate. After all the bids have been opened, they shall be initialed and dated on the first page of each bid by the members of the bid's opening committee. All the pages of the price schedule and letters, bill of quantities attached, shall be initialed and dated by the members of the committee. Key information such as prices, delivery period, etc. shall be encircled, and unfilled spaces in the bids shall be marked and signed with date by the members of the committee. The original and additional copies of the bid shall be marked accordingly. Shall be initialed legibly to make it clear that such alteration, etc., were existing in the bid at the time of opening. 9. No bid shall be rejected at the time of bid opening, except the late bids, alternative bids, if not permitted, and bids not accompanied with the proof of payment or instrument of the required price of bidding documents, processing fee or user charges, and bid security. 10. The bid opening committee shall prepare a record of the bid opening that shall include the name of the bidder, and whether there is a withdrawal, substitution, or modification, the bid price, per lot, if applicable, any discounts and alternative offers, if they were permitted, any conditions put by bidder and the proof of the payment of price of bidding documents, processing fee or user charges, and bid security. The bidders or their representatives who are present shall sign the record. The omission of a bidder's signature on the record shall not invalidate the contents and effect of the record. The members of the committee shall also sign the record with date. 11. In case of two-part bids, only outer envelopes and envelopes marked as technical bid shall be opened in the sequence of the serial numbers marked on them. The envelopes marked as financial bid shall be kept intact and safe, and shall be opened of only those bidders who qualify in the evaluation of their technical bids in the manner as mentioned in Subrule 3 to 10 above, on the date and time to be intimated to those bidders. 12. In case of two-stage bidding, the proposals received in response to invitation of expression of interest or request for qualification in the first stage shall be opened as per the procedure specified in Subrules 3 to 10 for the opening of single-part bid. The procedure for opening of second-stage bids shall be similar to that for opening of two-part bids, specified in Subrule 11. In case technical and financial bids are invited in single envelope in second stage, the procedure for opening of the bids shall be as specified in Subrule 3 to 10. 56. Preliminary examination of bids. The bid evaluation committee constituted by the procuring entity shall conduct a preliminary scrutiny of the opened bids to assess the prima facie responsiveness and ensure that the A bid is signed, as per the requirements listed in the bidding documents. B bid has been sealed as per instructions provided in the bidding documents. C bid is valid for the period specified in the bidding documents. D bid is accompanied by bid security or bid securing declaration. E bid is unconditional and the bidder has agreed to give the required performance security. And F other conditions as specified in the bidding documents are fulfilled. 57. Tabulation of technical bids. 1. If technical bids have been invited, they shall be tabulated by the bids evaluation committee in the form of a comparative statement to evaluate the qualification of the bidders against the criteria for qualifications set out in the bidding documents. The table may include following: A. Name and address of the bidder including email address, if any. B. Reference of registration empanelment, if any, with the procuring entity or other procuring entity. C. Is there any substitution or modification of the original bid? D. Whether the bidder fulfills the eligibility criteria given in the bidding documents. E. Whether the bid has been signed by the bidder or an authorized person, whether valid document of authority is enclosed. F. Whether proof of payment of price of bid documents given. G. Whether proof of payment of processing fee or user charges, if any, bid security or the instrument of bid security or bid securing declaration given. H. Response to the required qualification criteria and allotment of marks for them, or whether meets the minimum standards fixed for each criterion in the bidding documents for 1. Availability of financial resources. 2. Past performance and experience. 3. Technical and professional competence, including requirement of technical professional specialist personnel and availability of required machinery and equipment. 4. Managerial resources and competence. 5. Whether proof declaration has been given as required under clauses B to E of subsection 2 of section 7. 6. Any other qualification criteria fixed in accordance with the provisions of section 7. I. Result of evaluation of technical bids, whether qualified or not, if not, reasons thereof. 2. The members of bids evaluation committee shall give their recommendations below the table as to which of the bidders have been found to be qualified in evaluation of technical bids and sign it. 3. The format of the table given in subrule 1 may also be used, mutatis mutandis, for evaluation of proposals received in response to registration empanelment of bidders. Request for qualifications expression of interest in first stage of two-stage bidding process. This format may also be used, mutatis mutandis, for evaluation of technical bid in the second stage of the two-stage bidding, if technical bids have been invited separately. 58. Tabulation of financial bids. 1. After evaluation of technical bids, the financial bids shall be tabulated by the Bids Evaluation Committee in the form of a comparative statement to evaluate the lowest or most advantageous bid on the basis of evaluation criteria set out in the bidding documents. The table may include following: A. Name and address of the bidders including email address if any. B. If evaluation of technical bids has taken place, whether the bidder has qualified in evaluation of technical bids. C. Specifications of the subject matter of procurement offered. D. Rates quoted per unit, per item and total price of each item quoted or percentage above, below on the rates given in the bidding documents, as the case may be. E. Taxes as applicable shall be shown separately. F. Packing and forwarding charges, freight, insurance, etc. G. Total cost per unit, per item and all items including all cost and taxes. H. Discount, rebate if any if permitted. I. Alternative offers if permitted. J. Delivery completion period quoted. K. Validity period of bids quoted. L. Mode of payment quoted. M. Samples, trials offered if asked for, and results of sample testing and trials conducted. N. Guarantee warranty defect liability period quoted if asked for. O. Contract maintenance period quoted if asked for. P. Response to any other information asked for in the bidding documents. Q. Any conditions quoted different from those included in the bidding documents. R. Is there any material deviation, reservation, or omission from the required specifications and terms and conditions set out in the bidding documents? S. Result of evaluation of financial bid standing of the bidder in financial evaluation. T. Combined evaluation of technical and financial bids, if stipulated in the bidding document standing of the bidder in combined evaluation of technical and financial bids. 2. If only single part bids have been invited, then the information specified in Clause B, C, D, E, F, G and subclause V of Clause H of Subrule 1 of Rule 57 shall also be included in the table. 3. The table given in Subrule 1 may also be used for evaluation of financial bids in second stage of two-stage bidding. 4. The members of Bids Evaluation Committee shall give their recommendations below the table regarding lowest bid or most advantageous bid and sign it. 59. Determination of responsiveness. 1. The Bid Evaluation Committee shall determine the responsiveness of a bid on the basis of bidding documents and the provisions of subsection 2 of Section 7. 2. A responsive bid is one that meets the requirements of the bidding documents without material deviation, reservation, or omission where A. Deviation is a departure from the requirements specified in the bidding documents. B. Reservation is the setting of limiting conditions or withholding from complete acceptance of the requirements specified in the bidding documents. And C. Omission is the failure to submit part or all of the information or documentation required in the bidding documents. 3. A material deviation, reservation, or omission is one that A. If accepted shall I. Affect in any substantial way the scope, quality, or performance of the subject matter of procurement specified in the bidding documents, or Roman II limits in any substantial way, inconsistent with the bidding documents, the procuring entity's rights or the bidder's obligations under the proposed contract. Or B. If rectified, shall unfairly affect the competitive position of other bidders presenting responsive bids. 4. The Bid Evaluation Committee shall examine the technical aspects of the bid in particular, to confirm that all requirements of bidding document have been met without any material deviation, reservation, or omission. 5. The procuring entity shall regard a bid as responsive if it conforms to all requirements set out in the bidding documents, or it contains minor deviations that do not materially alter or depart from the characteristics, terms, conditions, and other requirements set out in the bidding documents, or if it contains errors or oversights that can be corrected without touching on the substance of the bid. 60. Clarification of bids. 1. To assist in the examination, evaluation, comparison, and qualification of the bids, the Bid Evaluation Committee may, at its discretion, ask any bidder for a clarification regarding its bid. The committee's request for clarification and the response of the bidder shall be in writing. 2. Any clarification submitted by a bidder with regard to its bid that is not in response to a request by the committee shall not be considered. 3. No change in the prices or substance of the bid shall be sought, offered, or permitted, except to confirm the correction of arithmetic errors discovered by the committee in the evaluation of the financial bids. 4. No substantive change to qualification information or to a submission, including changes aimed at making an unqualified bidder qualified, or an unresponsive submission, responsive shall be sought, offered, or permitted. 5. All communications generated under this rule shall be included in the record of the procurement proceedings. 61. Non-material nonconformities in bids. 1. The Bid Evaluation Committee may waive any nonconformities in the bid that do not constitute a material deviation, reservation, or omission. The bid shall be deemed to be substantially responsive. 2. The Bid Evaluation Committee may request the bidder to submit the necessary information or document like audited statement of accounts, PAN, etc., within a reasonable period of time. Failure of the bidder to comply with the request may result in the rejection of its bid. 3. The Bid Evaluation Committee may rectify non-material nonconformities or omissions on the basis of the information or documentation received from the bidder under Subrule 2. 62. Exclusion of bids. A procuring entity shall exclude a bid in accordance with the provisions of Section 25. 63. Evaluation of technical bids in case of two-part bids.
Definition. Techno-commercial, involving both technical and commercial aspects of a bid, such as qualifications, experience, and financial stability.
1. The criteria fixed for evaluation of technical bids shall be in accordance with the provisions of Section 7 and clearly mentioned in the bidding documents so as to keep transparency in selection process. The criteria once fixed for evaluation of technical bids shall not be changed or relaxed. 2. Techno-commercial qualifications of the bidders shall be evaluated in tabular form as per Rule 57 on the basis of the weightings of marks assigned or minimum achievements fixed in the bidding documents for various criteria of qualifications in the area of professional, technical, financial, managerial competence, etc., that is like number of years of experience of the bidder in the subject matter of procurement. Satisfactorily completion of similar contracts in past certain years, each valuing not less than specified percentage of the value of subject matter of procurement. Financial turnover of the bidder in past certain years in relation to the value of subject matter of procurement. The value of orders in hand of the bidder at the time of submitting the bid relative to the value of subject matter of procurement, etc. 3. Bidders securing specified minimum % of marks or have fulfilled minimum achievement norms may be considered to have technically qualified. 4. The number of firms qualified in technical evaluation should not generally be less than 3. If the number is less than 3, and it is considered necessary by the procuring entity to continue with the procurement process, reasons shall be recorded in writing and included in the record of the procurement proceedings. 5. The bidders who qualified in the technical evaluation shall be informed in writing about the date, time, and place of opening of their financial bids. This date should generally be not later than 15 days from the date of issue of letter. 64. Correction of arithmetic errors in financial bids. The Bid Evaluation Committee shall correct arithmetical errors in substantially responsive bids on the following basis, namely: A. If there is a discrepancy between the unit price and the total price that is obtained by multiplying the unit price and quantity, the unit price shall prevail, and the total price shall be corrected, unless, in the opinion of the bid evaluation committee, there is an obvious misplacement of the decimal point in the unit price, in which case the total price as quoted shall govern, and the unit price shall be corrected. B. If there is an error in a total corresponding to the addition or subtraction of subtotals, the subtotals shall prevail and the total shall be corrected. And C. If there is a discrepancy between words and figures, the amount in words shall prevail, unless the amount expressed in words is related to an arithmetic error, in which case the amount in figures shall prevail subject to clause A and B above. 65. Evaluation of financial bids subject to the provisions of Section 27. The procuring entity shall take following actions for evaluation of financial bids. A. In case of single-part bid system, where bid is received in single cover, along with requisite bid security, processing fee or user charges, and price of bidding documents within specified time, it shall be considered for financial evaluation by the Bids Evaluation Committee. B. In case of two-part bid system, the financial bids of the bidders who qualified in technical evaluation shall be opened at the notified time, date and place by the Bid Evaluation Committee in the presence of the bidders or their representatives who choose to be present. C. The process of opening, marking, and signing on the financial bids shall be as prescribed in Rule 55. D. The names of the bidders, the rates given by them, and conditions put, if any, shall be read out and recorded. E. Conditional bids are liable to be rejected. F. The evaluation shall include all costs and all taxes and duties applicable to the bidder, as per law of the central/state government/local authorities, and the evaluation criteria specified in the bidding documents shall only be applied. G. The offers shall be evaluated and marked L1, L2, L3, etc., L1 being the lowest offer, and then others in ascending order in case price is the only criteria, or evaluated and marked H1, H2, H3, etc. in descending order in case quality is also a criteria, and the combined score of technical and financial evaluation is considered. H. The Bid Evaluation Committee shall prepare a comparative statement in tabular form in accordance with Rule 58 with its report on evaluation of financial bids, and recommend the lowest offer for acceptance to the procuring entity, if price is the only criterion, or most advantageous bid in other case. I. It shall be ensured that the offer recommended for sanction is justifiable looking to the prevailing market rates of the goods, works, or service required to be procured. And J. In case a rate contract is being entered, more than one firm at the same lowest rate may be considered to ensure uninterrupted delivery, but for this purpose, counter-offer of lowest rate will be given for acceptance to the bidders quoting higher rates in the order of ascending value. 66. Comparison of rates of firms outside and those in Rajasthan, deleted.
Definition. Letter of intent, LOI. A document outlining an agreement in principle between two or more parties before a formal contract is created.
67. Price/purchase preference in evaluation price and/or purchase preference notified by the state government and as mentioned in the bidding documents shall be considered in the evaluation of bids and award of contract. 68. Lack of competition. 1. A situation may arise where, if after evaluation of bids the Bid Evaluation Committee may end up with one responsive bid only. In such situation, the Bid Evaluation Committee should check as to whether, while floating the notice inviting bids, all necessary requirements to encourage competition like standard bid conditions, industry-friendly specifications, wide publicity, sufficient time for formulation of bids, etc. were fulfilled. If not, the notice inviting bids should be refloated after rectifying deficiencies. The bid process shall be considered valid even if there is one responsive bid, provided that A. The bid is technically qualified, B. The price quoted by the bidder is assessed to be reasonable, C. The bid is unconditional and complete in all respects, D. There are no obvious indicators of cartelization amongst bidders, and E. The bidder is qualified, as per the provisions of Section 7, 2. The Bid Evaluation Committee shall prepare a justification note for approval of the procuring entity, clearly including views of the accounts finance member of the committee. 3. The procuring entity competent to decide a procurement case, as per delegation of financial powers, shall decide as to whether to sanction the single bid or re-invite bids after recording its reasons for doing so. 4. If a decision to re-invite the bids is taken, market assessment shall be carried out for estimation of market depth, eligibility criteria, and cost estimate. 69. Negotiations. 1. Except in case of procurement by method of single-source procurement or procurement by competitive negotiations, to the extent possible, no negotiations shall be conducted after the pre-bid stage. All clarifications needed to be sought shall be sought in the pre-bid stage itself. 2. Negotiations may, however, be undertaken only with the lowest or most advantageous bidder under the following circumstances. A. When ring prices have been quoted by the bidders for the subject matter of procurement, or B. When the rates quoted vary considerably and considered much higher than the prevailing market rates. 3. The Bid Evaluation Committee shall have full powers to undertake negotiations. Detailed reasons and results of negotiations shall be recorded in the proceedings. 4. The lowest or most advantageous bidder shall be informed in writing either through messenger or by registered letter and email, if available. A minimum time of 7 days shall be given for calling negotiations. In case of urgency, the Bid Time Evaluation Committee, after recording reasons, may reduce the time, provided the lowest or most advantageous bidder has received the intimation and consented to regarding holding of negotiations. 5. Negotiations shall not make the original offer made by the bidder inoperative. The Bid Evaluation Committee shall have option to consider the original offer in case the bidder decides to increase rates originally quoted or imposes any new terms or conditions. 6. In case of non-satisfactory achievement of rates from lowest or most advantageous bidder, the Bid Evaluation Committee may choose to make a written counter offer to the lowest or most advantageous bidder. And if this is not accepted by him, the committee may decide to reject and re-invite bids or to make the same counteroffer first to the second lowest or most advantageous bidder, then to the third lowest or most advantageous bidder, and so on in the order of their initial standing and work/supply order be awarded to the bidder who accepts the counteroffer. This procedure should be used in exceptional cases only. 7. In case the rates even after the negotiations are considered very high, fresh bids shall be invited. 70. Acceptance of the successful bid and award of contract. 1. The procuring entity, after considering the recommendations of the Bid Evaluation Committee and the conditions of bid, if any, financial implications, trials, sample testing and test reports, etc., shall accept or reject the successful bid. If any member of the Bid Evaluation Committee has disagreed or given its note of dissent, the matter shall be referred to the next higher authority, as per delegation of financial powers, for decision. 2. Decision on bids shall be taken within original validity period of bids and time period allowed to procuring entity for taking decision. If the decision is not taken within the original validity period or time limit allowed for taking decision, the matter shall be referred to the next higher authority in delegation of financial powers for decision. 3. Before award of the contract, the procuring entity shall ensure that the price of successful bid is reasonable and consistent with the required quality. 4. A bid shall be treated as successful only after the competent authority has approved the procurement in terms of that bid. 5. The procuring entity shall award the contract to the bidder whose offer has been determined to be the lowest or most advantageous, in accordance with the evaluation criteria set out in the bidding documents. And if the bidder has been determined to be qualified to perform the contract satisfactorily on the basis of qualification criteria fixed for the bidders in the bidding documents for the subject matter of procurement. 6. Prior to the expiration of the period of bid validity, the procuring entity shall inform the successful bidder, in writing, that its bid has been accepted. 7. As soon as a bid is accepted by the competent authority, its written intimation shall be sent to the concerned bidder by registered post or email, and asked to execute an agreement in the format given in the bidding documents on a non-judicial stamp of requisite value, and deposit the amount of performance security or a performance security declaration, if applicable. within a period specified in the bidding documents, or where the period is not specified in the bidding documents, then within 15 days from the date on which the letter of acceptance or letter of intent is dispatched to the bidder. 8. If the issuance of formal letter of acceptance is likely to take time, in the meanwhile a letter of intent, LOI, may be sent to the bidder. The acceptance of an offer is complete as soon as the letter of acceptance or letter of intent is posted and/or sent by email, if available, to the address of the bidder given in the bidding document. Until a formal contract is executed, the letter of acceptance or letter of intent shall constitute a binding contract. 9. The bid security of the bidders whose bids could not be accepted shall be refunded soon after the contract with the successful bidder is signed and its performance security is obtained. 71. Information and publication of award information of award of contract shall be communicated to all participating bidders and published on the State Public Procurement Portal in accordance with provisions of subsection 3 of Section 27. 72. Procuring entity's right to accept or reject any or all bids. The procuring entity reserves the right to accept or reject any bid, and to annul the bidding process and reject all bids at any time prior to award of contract, without thereby incurring any liability to the bidders. Reasons for doing so shall be recorded in writing. 73. Right to vary quantity, -1, 1 deleted, 1, 1, if the procuring entity does not procure any subject matter of procurement or procures less than the quantity specified in the bidding documents due to change in circumstances, the bidder shall not be entitled for any claim or compensation except otherwise provided in the bidding documents. 2. Orders for extra items may be placed by the procuring entity in accordance with the schedule of powers as prescribed by the Finance Department, up to 5% of the value of the original contract, if allowed in the bidding documents. The fair market value of such extra items payable by the procuring entity to the contractor shall be determined by the procuring entity in accordance with guidelines prescribed by the administrative department concerned. 3. Orders for additional quantities may be placed, if allowed in the bidding documents, on the rates and conditions given in the contract, and the original order was given after inviting open competitive bids. Delivery or completion period may also be proportionately increased. The limits of orders for additional quantities shall be as under: A. 50% of the quantity of the individual items and 50% of the value of original contract in case of works, and B. 50% of the value of goods or services of the original contract. Provided that in exceptional circumstances, and without changing the scope of work envisaged under the contract, a procuring entity may procure additional quantities beyond 50% of the quantity of the individual items, as provided in the original work order with prior approval of the administrative department, concerned as follows. 1. The procuring entity shall obtain prior approval for revised requirements from the competent authority for reasons to be recorded in writing. Wherever necessary, due to the quantum of orders for additional quantities, the procuring entity shall obtain prior and revised technical, financial, and administrative sanctions from the competent authorities. 2. That the additional quantities so procured shall be part and parcel of the work being executed. 3. That the limit of 50% of the value of original contract shall not be exceeded in any case. 74. Dividing quantities among more than one bidder at the time of award. As a general rule, all the quantities of the subject matter of procurement shall be procured from the bidder, whose bid is accepted. However, when it is considered that the quantity of the subject matter of procurement to be procured is very large, and it may not be in the capacity of the bidder, whose bid is accepted, to deliver the entire quantity, or when it is considered that the subject matter of procurement to be procured is of critical and vital nature. In such cases, the quantity may be divided between the bidder, whose bid is accepted, and the second lowest bidder or even more bidders in that order, in a fair, transparent, and equitable manner at the rates of the bidder, whose bid is accepted if such condition is specified in the bidding documents. Counter offer to first lowest bidder, L1, in order to arrive at an acceptable price, shall amount to negotiation. However, any counter offer thereafter to second lowest bidder, L2, third lowest bidder, L3, etc., at the rates accepted by L1 in case of splitting of quantities, as predisclosed in the bidding documents, shall not be deemed to be a negotiation. 75. Performance security. 1. Performance security shall be solicited from all successful bidders, except the 1 departments boards of the state government or central government. 2 government companies as defined in Clause 45 of Section 2 of the Companies Act, 2013. 3 company owned or controlled, directly or indirectly, by the central government, or by any state government or governments, or partly by the central government and partly by one or more state governments, which is subject to audit by the auditor appointed by the Comptroller and Auditor General of India under subsection 5 or 7 of Section 139 of the Companies Act, 2013. 4 autonomous bodies, registered societies, cooperative societies, which are owned or controlled or managed by the state government or central government. Or I-4 bidder in procurement related to Panchayat Samhuinenda Shala, January Sabhajita Yajana, or Gram Panchayat Gashala / Pashu Asharya Esthal, January Sabhajita Yajana, issued by the state government. However, a performance security declaration shall be taken from them. The state government may relax the provision of performance security in a particular procurement or any class of procurement. 2. The amount of performance security shall be 5%, or as may be specified in the bidding documents, of the amount of supply order in case of procurement of goods and services, and 10% of the amount of work order in case of procurement of works. In case of micro, small and medium enterprises, of Rajasthan it shall be 1% of the amount of quantity ordered for supply of goods or service to be rendered, and in case of sick industries, other than micro, small and medium enterprises, whose cases are pending before the Board of Industrial and Financial Reconstruction, BIFR, it shall be 2% of the amount of supply order, provided that during the period commencing from the date of commencement of the Rajasthan Transparency in Public Procurement, Second Amendment, Rules 2020-31, 03/2023, the performance security shall be taken as under a 2.5%, or as may be specified in the bidding documents, of the amount of supply order in case of procurement of goods and services, and 3% of the amount of work order in case of procurement of works. B. 0.5% of the amount of quantity ordered for supply of goods in case of small-scale industries of Rajasthan. And C. 1% of the amount of supply order in case of sick industries other than small-scale industries, whose cases are pending before the Board of Industrial and Financial Reconstruction, BIFR. And provided further that where the bid for procurement of works is invited under the hybrid annuity model, HAM, projects, the performance security shall be 5% of amount of work order. Explanation. For the purpose of this proviso hybrid annuity model, HAM, project means a public-private partnership where the government provides a portion of the project cost. The remaining portion of the project cost will have to be raised by private developer, which is covered through annuity payments from the government to the private developer. 2a. Notwithstanding anything contained in subrule 2 above, where the state government being of the opinion that there exist grave situations, such as natural calamity, or pandemic, or epidemic diseases, or floods, etc., in which the economy is adversely affected, the state government may, by order, direct the procurement entity to reduce the performance security taken in case of existing contracts of ongoing projects, from such date and on such conditions as may be specified in the order. 3. Performance security shall be furnished in any one of the following forms: A. Deposit though EGRAS. B. Bank draft or banker's check of a scheduled bank. C. National savings certificates and any other script instrument under national savings schemes for promotion of small savings issued by a post office in Rajasthan, if the same can be pledged under the relevant rules. They shall be accepted at their surrender value at the time of bid and formally transferred in the name of procuring entity with the approval of head postmaster. D. Bank guarantee or electronic bank guarantee (EBG) of a scheduled bank. It shall be got verified from the issuing bank. Other conditions regarding bank guarantee shall be same as mentioned in the Rule 42 for bid security. E. Fixed deposit receipt, FDR, of a scheduled bank. It shall be in the name of procuring entity on account of bidder and discharged by the bidder in advance. The procuring entity shall ensure before accepting the fixed deposit receipt that the bidder furnishes an undertaking from the bank to make premature payment of the fixed deposit receipt on demand to the procuring entity without requirement of consent of the bidder concerned. In the event of forfeiture of the performance security, the fixed deposit shall be forfeited along with interest earned on such fixed deposit. Insurance surety bonds issued by insurer registered with the Insurance Regulatory and Development Authority of India, IRDA, for transact the business of issuing insurance surety bonds. And F, in case of procurement of works, the successful bidder at the time of signing of the contract agreement may submit option for deduction of performance security from his each running and final bill at 10% of the amount of the bill, the set of complex numbers of provided that, during the period commencing from the date of commencement of the Rajasthan Transparency in Public Procurement, Second Amendment. Rules, 2020 to there exists, in case of procurement of works. The successful bidder at the time of signing of the contract agreement may submit option for deduction of performance security from his each running and final bill, the set of rational numbers, 3% of the amount of the bill. 4. Performance security furnished in the form specified in Clause B to E of Subrule 3 shall remain valid for a period of 60 days beyond the date of completion of all contractual obligations of the bidder, including warranty obligations and maintenance and defect liability period.
4 definitions. Definition 1. Unbalanced bid. A bid where some line items are priced significantly lower than their estimated cost, while others are priced higher. Such bids may be submitted to gain an unfair advantage. Definition 2. Estimated bid value. The value of the procurement as estimated by the procuring entity. Definition 3. Bid amount. The total price offered by a bidder for the subject matter of procurement. Definition 4. Unbalanced bid amount. The amount that exceeds the specified percentage of estimated bid value.
Explanation. For the purpose of this rule, 1. Unbalanced bid means any bid below more than 15% of estimated bid value. 2. Estimated bid value means value of subject matter of procurement mention in bidding documents by the procuring entity. 3. Unbalanced bid amount means positive difference of 85% of estimated bid value minus bid amount quoted by the bidder. C.76. Execution of agreement. 1. A procurement contract shall come into force from the date on which the letter of acceptance or letter of intent is dispatched to the bidder. 2. The successful bidder shall sign the procurement contract within a period specified in the bidding document, or where the period is not specified in the bidding document, then within 15 days from the date on which the letter of acceptance or letter of intent is dispatched to the successful bidder. 3. If the bidder, whose bid has been accepted, fails to sign a written procurement contract or fails to furnish the required performance security within specified period, the procuring entity shall take action against the successful bidder, as per the provisions of the Act and these rules. The procuring entity may, in such case, cancel the procurement process, or if it deems fit, offer for acceptance the rates of lowest or most advantageous bidder to the next lowest or most advantageous bidder, in accordance with the criteria and procedures set out in the bidding documents. 4. The bidder shall be asked to execute the agreement on a non-judicial stamp of specified value at its cost. 77. Confidentiality. In addition to the restrictions specified in Section 49, the procuring entity, while procuring a subject matter of such nature which requires the procuring entity to maintain confidentiality, may impose condition for protecting confidentiality of such information. 78. Cancellation of procurement process. If any procurement process has been cancelled, it shall not be reopened, but it shall not prevent the procuring entity from initiating a new procurement process for the same subject matter of procurement, if required. 79. Documentary record of procurement proceedings. 1. Subject to the provisions of Section 10, the procuring entity shall, in addition to records specified in Clause A to H of subsection 1, if the said section, maintain the following record, namely: A. The names and addresses of all bidders with bid prices and conditions of bid if bid is conditional. B. The name and address of the successful bidder with price on which procurement is made. C. In case of rate contract method, the names and addresses of the bidders with whom the rate contract is concluded. D. A summary of modification, if any, made in the bidding documents. E. Details of qualification required, bidders having qualifications and details of qualified or disqualified bidders with reasons. F. Where a written procurement contract has been executed, including rate contract, copy of contract. G. In the case of empanelment, the terms and conditions of the empanelment and a copy of the agreement, if any. H. A summary of the evaluation and comparison of bids, including the application of any margin of preference and reasons for rejection or non-consideration of a bid, if any. And I. If the procurement process is cancelled, reasons of cancellation. 1 Chapter VA Bid Process Management Swiss Challenge Method.
6 definitions. Definition 1. Value for money. A criterion in procurement that emphasizes not just the lowest price, but the best possible outcome for the resources expended, considering quality, life cycle costs, and other factors. Definition 2. Net present value, NPV. The difference between the present value of cash inflows and the present value of cash outflows over a period of time. Definition 3. Internal rate of return, IRR. A metric used in capital budgeting to estimate the profitability of potential investments. IRR is a discount rate that makes the net present value, NPV, of all cash flows from a particular project equal to 0. Definition 4. Equity-debt ratio. The ratio indicating the relative proportion of equity and debt used in financing a company's assets. Definition 5. Value for money analysis. A process used to assess whether a project provides the best possible outcome for the resources invested. Definition 6. Transaction advisor. Advisors or consultants to assist and guide in financial transactions.
79. A Swiss challenge method of procurement. The Swiss challenge method is a method in which an unsolicited proposal for a government project is received and allows third party to challenge the original proposal through open bidding, and then lets the original proponent countermatch the most advantageous / most competitive offer. 79. Be eligible sectors under Swiss challenge method. In following sectors Swiss challenge method of procurement may be adopted, namely: 1. Agriculture, horticulture, allied sector and post-harvest management, agri-infrastructure, agriculture and horticulture markets, floriculture, parks and markets, agro-food processing and allied infrastructure, including common user cold storage facilities. 2. Transportation and logistics, roads, including bridges, highways, interchanges and flyovers, public transport, railway systems, urban transport systems, MRTS, LRTS, monorail, high-capacity bus systems, airstrips, inland water transport, bus truck, urban transport terminals, and associated public facilities such as public amenities centers. 3. Warehousing infrastructure, including container freight stations, container depots, cold storage facilities, and tank farms. 4. Mechanized and multi-story parking facilities. 5. Urban and municipal infrastructure, sanitation, water supply and sewerage, desalination, underground drainage, solid waste, biomedical waste, hazardous waste, collection, transportation, treatment, and disposal facilities. 6. Education, including technical education, skill development, etc. 7. Gas distribution network. 8. Medical and health sector. 9. Housing sector and environment. 10. Information technology. 11. Water body ecosystem management. 12. Industrial infrastructure. 13. Irrigation sector. 14. Land reclamation. 15. New and renewable energy, solar, wind, tidal, etc. 16. Power sector. 17. Public buildings, markets, gardens, parks. 18. Sports and recreation infrastructure. 19. Trade fair, convention, exhibition, and cultural centers. 20. Tourism sector. 21. Water supply project. 22. Upgradation and restructuring of any of the projects in above sectors. 23. Any project in public-private partnership that the state government may find beneficial. 24. Any proposal for the partial or complete disinvestment of a state public sector undertaking. 25. Any other project, which is a combination of above-mentioned sectors. And Roman 26, on recommendations, with appropriate justifications, of the Administrative Department for inclusion of any new sector, SLEC may recommend for inclusion of the same to the state government. Any new sector can be added to the list of eligible sectors of these rules only after the consent of the Finance Department of State Government on the recommendations of the SLEC. 79C projects, which shall not be acceptable under Swiss challenge method. The following proposals shall not be acceptable under Swiss challenge method, namely, 1. Proposals which contravene the provisions of any law that is in force. 2. Projects which would result in monopolistic situation. 3. Projects which are less than Rs. 50 crores Rs. 50 crores in value. 4. Proposals/projects that fall outside the sectors and below the financial limits as prescribed in these rules. 5. Proposals of PPP projects involving financial assistance from state government by way of viability gap funding, VGF, more than 20% of the total project cost, excluding the cost of land. 79D procedure. 1. The project proponent or his authorized representative shall submit an application along with certificate in Form No. 2 and details of proposal in Form No. 3 to the Administrative Department. If pre-feasibility report or detailed project report is available, then same shall also be submitted with application. The contents of pre-feasibility report shall be as specified in Form No. 4, and the contents of detailed project report shall be as specified in Form No. 5. 2. The Administrative Department shall scrutinize the proposal as to whether it falls into the purview of the department's development plans and whether public need is established, and the proposal prima facie addresses the public need and requirement. 3. If the Administrative Department finds that the proposal received under Swiss challenge method has no uniqueness and is similar to the procurement of goods work services that is already being done under conventional method, then the Administrative Department would be under an obligation to reject such a proposal. But in case, if the Administrative Department considers that a proposal received is appropriate to be taken under Swiss challenge method, despite its being similar to the procurement being done under conventional methods, then it would record reasons in writing for accepting it under Swiss challenge method. 4. The Administrative Department shall examine and offer its comments regarding the proposal submitted by project proponent. After examination, if the Administrative Department is satisfied that the conditions specified in Subrule 2 above are fulfilled, it shall submit its recommendations to the State-Level Empowered Committee, SLEC, through Planning Department of the state government, for according the permission to proceed. 5. The Planning Department shall arrange and coordinate the meetings of the SLEC. The SLEC, after necessary examination, may accord the permission to proceed with or without modifications. The permission to proceed shall be conveyed by the Principal Secretary, Planning Department to the Administrative Department concerned. On receipt of the permission to proceed, the same shall be exhibit by the Administrative Department on State Public Procurement Portal. 6. After obtaining permission to proceed from SLEC, a letter shall be issued by the Administrative Department to the project proponent allowing a period of 3 months for undertaking detailed studies, including preparation of detailed project report required for bidding, and submit the detailed and comprehensive proposal to Administrative Department. In case the project proponent fails to submit detailed and comprehensive proposal within a period of 3 months and submits written request to the Administrative Department, the Administrative Department may, in appropriate case, after recoding reasons in writing, extend the period specified above. 7. If the project proponent fails to submit the detailed and comprehensive proposal within a specified period or extended period, as the case may be, the Administrative Department may, at its discretion, exercise the option to develop the project on its own or through its agencies or through any third party, without the project proponent having any claims, and if the Administrative Department exercises the option in the manner as specified above, it shall be exhibit by the Administrative Department on State Public Procurement Portal. 79. Preparation and submission of detailed and comprehensive proposal. 1. The project proponent shall submit a detailed and comprehensive proposal in Form No. 6, along with detailed project report in hard copy and soft copy. earnest security equal to 0.05% of the total estimated cost of the project, bid value financial proposal IRR, etc., with details and supporting documents, wherever necessary. Project financial summary in Form Number 7, and checklist for submission of documents in Form Number 8 within a period specified in Rule 79D to the Administrative Department in hard copy and soft copy. 2. It should be ensured by the project proponent that all financial reports and/or the documents having financial details must be duly verified from a competent chartered accountant. 3. The Administrative Department may carry out additional studies for independently determining the project cost, project revenues, viability and risk analysis, etc., to ensure proper benchmarking. 4. The project proponent shall submit the detailed and comprehensive proposal in 2 covers. The first cover shall include the detailed project report, the survey data, specifications, input-output, as well as designs of the project, total estimated cost of the project on the basis of detailed project report, cost of preparation of detailed project report, along with the earnest security. The detailed project report shall include the details as specified in Form Number 5. The first cover shall be opened by the Administrative Department, or by a committee constituted by the Administrative Department for this purpose. The bid value, in such form as may be required by the Administrative Department, shall be submitted in a separate cover, duly sealed by the project proponent, which shall be opened by the Administrative Department or by a committee constituted by the Administrative Department for this purpose, only at the time of opening of the financial bids received from other bidders through open competitive bidding process. 79F. Earnest security. The project proponent shall furnish interest-free earnest security as a token of sincerity and good faith, amounting to 0.05% of the total estimated cost of the project through demand draft or L-squared bank guarantee or electronic bank guarantee, EBG, acceptable to the Administrative Department concerned, with a validity period of not less than 180 days commencing from the date of submission of detailed and comprehensive proposal, including claim period of 60 days, to be extended as may be mutually agreed from time to time. The bid shall be summarily rejected if the detailed and comprehensive proposal is not accompanied by the earnest security. 2. The project proponent shall also submit the requisite bid security as specified in the bid document, in case the bidding process is initiated under the proposed project by the Administrative Department concerned. The bid security shall be calculated on the basis of the total estimated cost of the project as per the detailed project report. The project proponent shall be required to furnish the bid security as specified in the bid document by the last date and time fixed for submission of bids under the bidding process initiated for the proposed project. The earnest security furnished by the project proponent earlier shall be adjusted against the bid security. If project proponent fails to furnish bid security of required amount within the time specified in bid document, his earnest security shall be forfeited, and he shall have no right as the project proponent. 79G. Detailed Project Report, DPR, Preparation Cost. 1. The direct cost of preparing the DPR shall be mentioned by the project proponent in detailed and comprehensive proposal. The DPR preparation cost shall include external payout, internal cost, out-of-pocket expenses and taxes, all accompanied by original receipts. 2. The Administrative Department or a committee, constituted by the Administrative Department for this purpose, shall negotiate the cost of preparation of the detailed project report with the project proponent and ensure that such assessment of the detailed project report preparation cost shall be reasonable and justifiable. The reimbursement of detailed project report preparation cost to the project proponent shall be 0.1% of the final bid value or of the approved negotiated cost of preparation of detailed project report, whichever is lower. 3. The cost of preparation of DPR, as determined under Subrule 2 above, may be reimbursed to the project proponent only in the case of final selection of successful bidder, if it is other than the project proponent, and only after the procuring entity has entered into agreement with such successful bidder. The cost of preparation of the DPR, payable to the project proponent shall be recovered from the successful bidder as specified in the bid document, provided that the project proponent shall not be entitled for the cost of preparation of DPR if he fails to furnish bid security as specified in Subrule 2 of Rule 79F4. In case, for any reason whatsoever, the project is not taken up by the administrative department, the cost of preparation of DPR shall not be reimbursed to the proposal proponent. 79. H. Clarifications regarding detailed project report, DPR. No changes shall be permitted in the DPR once the project proponent has submitted the DPR to the administrative department concerned. However, the administrative department may seek clarifications with respect to the DPR from the project proponent, and these clarifications shall be attached as an addendum to the DPR. 79. I. Bid parameters and bid value. 1. The project proponent shall submit the detailed and comprehensive proposal, along with the bid parameters and bid value. The decision on the bid parameters shall be taken by the administrative department concerned, and the administrative department shall have the authority to make changes to the project proposal, as per the needs, requirements, and development plans of the administrative department, without changing the basic theme and fundamental structure of the project proposal. Any such change in the bid parameters shall be intimated to the project proponent if required. The administrative department may provide an additional time of 15 days to the project proponent for submitting the final bid value. If the additional time is allowed under Subrule 1, the project proponent shall submit the final bid value in such form as may be required by the administrative department. After submission of final bid value by the project proponent, the original bid value submitted by the project proponent shall become inoperative. The final bid value shall be submitted in a separate cover, duly sealed by the project proponent, which shall be opened only at the time of opening of the financial bids received from bidders through open competitive bidding process. In case the project proponent desires to give additional information, he may enclose such information separately. After submission of the final bid value by the project proponent, the administrative department shall submit the proposal, with appropriate recommendation, to the state-level empowered committee. 79. J. Competent authority for approval of projects under SCM and procedure to be followed thereof. 1. After examination of the detailed and comprehensive proposal, the administrative department shall submit detailed and comprehensive proposal along with its recommendation to SLEC for consideration. The administrative department shall also indicate the budgetary provisions for the project proposal. 2. On receipt of recommendation of the administrative department, the SLEC shall examine, consider, and grant approvals on merits. 79K bidding process. 1. The DPR, except for proprietary technology details, shall be shared with prospective bidders so as to ensure fair competition and for providing an opportunity for a competitive bidding process. The open competitive bidding process, as provided in Chapter V of these rules, shall be initiated by the administrative department concerned after approval of the project proposal from SLEC. 2. The bidding document, among other essential clauses, shall incorporate details about the necessary clearances approvals to be taken from respective authorities, and who, that is the administrative department or the successful bidder project proponent, shall be responsible for taking it, keeping in view the nature and requirements of individual project. The bidding document shall clearly incorporate that the open bidding process is being taken up under SWIL challenge method of procurement. 3. After examination of the bids, if the proposal of the project proponent is found to be lowest or most advantageous, as the case may be, in accordance with the evaluation criteria as specified in bidding document, then the project proponent shall be selected and awarded the project. In case bid of other bidder is found lowest or most advantageous, as the case may be, the project proponent shall be given an opportunity to match the lowest or most advantageous bid within a period as specified. If the project proponent agrees to match the lowest or most advantageous bid within the time period specified, the project proponent shall be selected and awarded the project. In case the project proponent fails to match the lowest or most advantageous bid within the period specified, the bidder who has submitted lowest or most advantageous bid as the case may be, shall be selected and awarded the project. 2. Provided that, if through the open bidding process, bid of other bidder is found lowest or most advantageous, as the case may be, the project proponent shall be given an opportunity to match such lowest or most advantageous bid, only if the final bid value offered by the project proponent is within 15% of such lowest or most advantageous bid, as the case may be. 79L Transaction Advisor. 1. The administrative department concerned may appoint a transaction advisor for the project or entrust the responsibility on officer of the department. The transaction advisor shall be capable to offer technical, financial, and legal advice and assist the administrative department concerned in finalization of the successful bidder. 2. In case the administrative department desires to appoint a transaction advisor for a project proposal received under Swiss challenge method, it may initiate the process of the appointment of the transaction advisor immediately after the permission to proceed is granted by the SLEC in order to save time in the process. It shall be ensured by the administrative department that the process of appointment of the transaction advisor is completed before submission of DPR by the project proponent. 3. The functions and responsibilities of the transaction advisor shall be as under. I. He shall examine the DPR with respect to technology, technical specifications, cost estimates, drawings, internal rate of return IRR, net present value NPV, equity debt ratio, value for money analysis, necessary approvals, statutory or otherwise, required for the implementation of the project, etc. 2. He, if required by the administrative department, shall carry out additional studies for independently determining the project cost, project revenues, viability and risk analysis, etc., including value for money analysis to ensure proper benchmarking. 3. He shall be required to specify broad parameters regarding environment and social safeguards that need to be adhered by the concessionaire during implementation period in the bid document. 4. He shall assist the administrative department to get necessary approvals from appropriate authorities for the implementation of the project. 5. He shall develop documents for request for qualification, RFQ/request for proposals, RFP, and submit to the administrative department concerned for approval. The bidding criteria shall be designed in such a way that maximum competition is ensured. 6. He shall develop and present the RFP and the concession agreement to the concerned authorities for approval, and after competent approval, the same shall be launched into the market. 7. He shall assist the administrative department concerned with the bid process management, including request for proposal, RFP, launch, formulation of responses to bidder queries, bid evaluation and recommendations as per the criteria mentioned in the RFP document, recommending a bidder, contract negotiations, and bid closure which are required to be undertaken for bringing the project to a technical close. 8. He shall submit all the documents for approval to the administrative department. He shall not provide any document to the bidder, S, or any other person, S, without explicit consent from the administrative department concerned. And 9. He shall perform any other functions or responsibilities assigned by the administrative department. 79M Time frame for the total process. The time frame for procurement through Swiss challenge method shall be as under. Provided that, in appropriate cases, the administrative department may relax the above-mentioned period. 79. Eligibility criteria for the project proponent. 1. The legal entity or person, including joint venture or consortium, shall be eligible for submitting proposal as project proponent if 1. The person or lead member shall have an average turnover of minimum of 100% project cost in the last 3 financial years, and in case of joint venture consortium, an average turnover of minimum of 100% of project cost in last 3 financial years by lead member, and the audited balance sheets of last 3 financial years shall be submitted. 2. The person or lead member or any other member of the joint venture or consortium shall have experience in handling at least one project in that sector in which the proposal is being submitted, costing not less than 100% of total project cost over the last 10 years in such project, S, where the contract has been awarded and work has been completed. Work order and completion certificate from the client shall be provided. 3. He shall not be blacklisted by central government, any state government, or any government agency. He shall submit an undertaking to the effect that he has not been blacklisted by central government, any state government, or any government agency. And 4. He shall necessarily fulfill the pre-qualification/qualification criteria parameters for bidders, as per the bid document issued by the Administrative Department for open bidding process for the project. 2. In case of consortium, a person authorized through power of attorney executed by all the members in his favor shall sign the proposal on behalf of all the member of the consortium, and such power of attorney shall be submitted along with the proposal. 3. In case of joint venture or consortium, the lead member, and the member of joint venture or consortium, on the basis of whose technical capability, the technical eligibility of joint venture or consortium for the project is decided, shall not be allowed to exit from the joint venture or consortium, provided that, if the lead member of the joint venture or consortium intends to exit the joint venture or consortium, then the proposed exit may be allowed by the administrative department concerned after ensuring the following, namely: A. The provisions relating to terms and conditions for such exit have been clearly specified in the bidding document and in the contract entered into by procuring entity with the joint venture or consortium, whose lead member intends to exit. B. A written request, along with submitting an in-principle approval from other members of the joint venture consortium, lender, competent member, proposed to be substituted in place of the lead member, etc., has been made by the lead member to the administrative department for such exit. C. Such exit shall be sanctioned by the administrative department only after expiry of at least 2 years from the date of completion of the project. D. All necessary measures shall be taken by administrative department to ensure that such exit shall not negatively affect the operation and maintenance of the project. E. No such exit shall be allowed until and unless a competent substitute is duly proposed for replacement in the joint venture consortium, and such replacement is diligently approved by the administrative department. F. The lead member shall be under an obligation to clear all government dues pending against the lead member on the date of application for such exit, and thus the administrative department concerned shall ensure there are no outstanding dues whatsoever against the lead member on the date of such exit. 4. In case of one company, certificate of incorporation. 2. In case of firm, certificate of registration. And 3. In case of partnership firm, partnership deed shall be submitted along with the proposal. 79. Power to call off the project. The administrative department concerned shall have the right to call off the project anytime during the process, without assigning any reason to the project proponent. But it may call off the project before entering into an agreement with the project proponent or the successful bidder, as the case may be. Once an agreement is entered into by the administrative department concerned, the respective clauses of the duly entered agreement shall apply. If the administrative department calls off the project in the manner as specified above, the same shall be exhibit by the administrative department on State Public Procurement Portal.
Table summary. The table outlines the time required for various activities in the procurement process, ranging from 1 month for preliminary report examination to 15 days for bid evaluation and proponent matching, with bid invitations varying based on publication and bidding type, and contract execution within 15 days of the award letter.
Chapter VI. Code of Integrity. 80. Code of Integrity. 1. All the officers or employees of the procuring entity shall A. Maintain an unimpeachable standard of integrity both inside and outside their office. B. Act in accordance with the provisions of the Act, these rules, guidelines issued under the Act and instructions. C. Not allow any bidders to have access to information on a particular procurement before such information is available to the public at large. D. Not intentionally use unnecessarily restrictive or tailored specifications, terms of reference or statements of work that can discourage competition. E. Not solicit or accept any bribe, reward or gift or any material benefit of any directly or indirectly promise of future employment from anyone, who has sought or is seeking procurement from the procuring entity. F. Not have a financial interest in any bidder. S. Responding to a procuring entity's bidding process, and any person having financial interest in any bidder shall not participate in that procurement process. G. Not disclose proprietary and source selection information, directly or indirectly, to any person other than a person authorized to receive such information. H. Treat all bidders in a fair and equitable manner in line with the principle of fairness, integrity, and transparency in the procurement process. I. Provide all bidders identical information at the same time during the bidding process. J. Apply the same criteria of evaluation as specified in the bidding documents, bidder registration documents, or pre-qualification documents, and under no circumstances new evaluation criteria shall be introduced during the evaluation process. K. Not entertain any favor, recreation, presents, services, etc. from the bidders or prospective bidders. L. Protect the interests of the procuring entity under all circumstances while dealing with information and information sources. M. Maintain confidentially of all bids. N. Ensure that the selection of bidder is as per the bidding documents and is not influenced by personal reasons attributable to concerned officials in any manner. And O. Disclose conflict of interest, if any. 2. Any person participating in procurement process shall A. Not offer any bribe, reward or gift or any material benefit either directly or indirectly in exchange for an unfair advantage in procurement process or to otherwise influence the procurement process. B. Not misrepresent or omit information that misleads or attempts to mislead so as to obtain a financial or other benefit or avoid an obligation. C. Not indulge in any collusion, bid rigging or anti-competitive behavior to impair the transparency, fairness, and progress of the procurement process. D. Not misuse any information shared between the procuring entity and the bidders with an intent to gain unfair advantage in the procurement process. E. Not indulge in any coercion including impairing or harming or threatening to do the same, directly or indirectly, to any party or to its property to influence the procurement process. F. Not obstruct any investigation or audit of a procurement process. G. Disclose conflict of interest, if any, and H. Disclose any previous transgressions with any entity in India or any other country during the last 3 years or any debarment by any other procuring entity. 81. Conflict of interest. 1. A conflict of interest for procuring entity or its personnel and bidders is considered to be a situation in which a party has interests that could improperly influence that party's performance of official duties or responsibilities, contractual obligations, or compliance with applicable laws and regulations. 2. The situations in which a procuring entity or its personnel may be considered to be in conflict of interest includes, but not limited to, following. A. A conflict of interest occurs when procuring entities' personnel's private interests, such as outside professional or other relationships or personal financial assets, interfere or appear to interfere with the proper performance of its professional functions or obligations as a procurement official. B. Within the procurement environment, a conflict of interest may arise in connection with such private interests as personal investments and assets, political or other outside activities and affiliations while in the service of the procuring entity, employment after retirement from the procuring entity's service, or the receipt of a gift that may place the procuring entity's personnel in a position of obligation. C. A conflict of interest also includes the use of procuring entities' assets, including human, financial, and material assets, or the use of procuring entities' office or knowledge gained from official functions for private gain, or to prejudice the position of someone procuring entities' personnel does not favor. D. A conflict of interest may also arise in situations where procuring entities' personnel is seen to benefit, directly or indirectly, or allow a third party, including family, friends, or someone they favor, to benefit from procuring entities' personnel's actions or decisions. 3. A bidder may be considered to be in conflict of interest with one or more parties in a bidding process if, including but not limited to, A. They have controlling partners in common, B. They receive or have received any direct or indirect subsidy from any of them, C. They have the same legal representative for purposes of the bid. D. They have a relationship with each other, directly or through common third parties, that puts them in a position to have access to information about or influence on the bid of another. E. A bidder participates in more than one bid in the same bidding process. However, this does not limit the inclusion of the same subcontractor, not otherwise participating as a bidder, in more than one bid. Or F. A bidder or any of its affiliates participated as a consultant in the preparation of the design or technical specifications of the subject matter of procurement of the bidding process. All bidders shall provide in qualification criteria and bidding forms a statement that the bidder is neither associated nor has been associated directly or indirectly with the consultant or any other entity that has prepared the design, specifications, and other documents for the subject matter of procurement or being proposed as project manager for the contract. 82. Breach of code of integrity by the bidder. Without prejudice to the provisions of Chapter 4 of the Act, in case of breach of any provision of the code of integrity by a bidder or prospective bidder, as the case may be, the procuring entity may take appropriate action in accordance with the provisions of subsection 3 of Section 11 and Section 46. Chapter VII. Appeals. 83. Form of appeal. 1. An appeal under subsection 1 or 4 of Section 38 shall be in form along with as many copies as there are respondents in the appeal. 2. Every appeal shall be accompanied by an order appealed against, if any, affidavit verifying the facts stated in the appeal and proof of payment of fee. 3. Every appeal may be presented to first appellate authority or second appellate authority, as the case may be, in person or through registered post or authorized representative. 84. Fee for filing appeal. 1. Fee for first appeal shall be Rs. 2,500, and for second appeal shall be Rs. 10,000, which shall be non-refundable. 2. The fee shall be paid in the form of bank demand draft or banker's check of a scheduled bank payable in the name of appellate authority concerned. 85. Procedure for disposal of appeal. 1. The first appellate authority or second appellate authority, as the case may be, upon filing of appeal, shall issue notice accompanied by copy of appeal, affidavit, and documents, if any, to the respondents and fixed date of hearing. 2. On the date fixed for hearing, the first appellate authority or second appellate authority, as the case may be, shall A. hear all the parties to appeal present before him, and B. peruse or inspect documents, relevant records or copies thereof relating to the matter. 3. After hearing the parties, perusal or inspection of documents and relevant records or copies thereof relating to the matter, the appellate authority concerned shall pass an order in writing and provide the copy of order to the parties to appeal free of cost. 4. The order passed under Subrule 3 shall also be placed on the State Public Procurement Portal. 86. Repeal and savings all rules, regulations, orders, notifications, departmental codes, manuals, bylaws, official memoranda, or circulars relating to procurement of goods, services, or works provided for in these rules, which are in force on the date of commencement of these rules, in relation to the matter covered by these rules, are hereby repealed to the extent they are covered by these rules, provided that such repeal shall not affect the previous operation of rules, regulations, orders, notifications, departmental codes, manuals, bylaws, official memoranda, or circulars, so repealed, and the procurement process commenced before the commencement of these rules shall continue as per the provisions of rules, regulations, orders, notifications, departmental codes, manuals, bylaws, official memoranda, or circulars, so repealed. Form Number 1C Rule 83, Memorandum of Appeal under the Rajasthan Transparency in Public Procurement Act, 2012 Appeal No. Before the First/second appellate authority, 1. Particulars of appellant. 1. Name of the appellant. 2. Official address, if any. 3. Residential address. 2. Name and address of the respondent S. I. Roman 2. Roman 3. 3. Number and date of the order appealed against and name and designation of the officer/authority who passed the order, enclosed copy, or a statement of a decision, action, or omission of the procuring entity in contravention to the provisions of the act by which the appellant is aggrieved. 4. If the appellant proposes to be represented by a representative, the name and postal address of the representative. 5. Number of affidavits and documents enclosed with the appeal. 6. Grounds of appeal. Supported by an affidavit. 7. Prayer, place date. 1. Form No. 2. See Rule 79D. Certificate to be furnished by project proponent. It is hereby certified that 1. The name of project has been submitted by the undersigned as the duly authorized representative of name of project proponent under the Swiss challenge method. 2. The project proponent will support fair competition through open bidding process to obtain the most advantageous bid. 3. The project proponent agrees to the standard project structure, bidding documents, concession agreements similar to other projects in the sector as decided by the Administrative Department/Government of Rajasthan. 4. The project proponent agrees to abide by the regulatory authority as and when formed by the Government of Rajasthan or through law. 5. The project proponent agrees that the cost of preparation of DPR, as decided by the Administrative Department, shall be reimbursable to the project proponent as provided in Rajasthan Transparency in Public Procurement Rules, 2013. 6. The project proponent agrees that the Administrative Department concerned has the right to call off the project anytime during the process without assigning any reason, but the Administrative Department may call off the project before entering into an agreement with the project proponent or the successful bidder, as the case may be. 7. The project proponent is technically and financially competent to handle the project implementation for which the proposal has been submitted. 8. The project proponent understands and agrees that if the project proponent fails to submit the detailed proposal DPR within the time given by the Administrative Department for the same, then the Administrative Department may at its discretion exercise the option to develop the project on its own, through its agencies or through any third party, without the project proponent having any claims whatsoever. 9. The project proponent agrees to abide by the Rajasthan Transparency in Public Procurement Act, 2012, and Rajasthan Transparency in Public Procurement Rules, 2013. 10. That the above statements are true to the best of my knowledge and belief. Dated, signature, name and designation of authorized representative of project proponent. Form number 3, see Rule 79D, details of proposal by project proponent. Name of the project proponent. Note: 1. While preparing this form, the placement of relevant references in the proposal have been indicated above. 2. Appropriate response to queries in yes/no, where applicable, has been given and details, as required, have been elaborated under particulars column. 3. It is agreed that the above form could be modified or additional information sought by the Administrative Department concerned at any time in future. 4. The above form is provided in signed hard copy and also in soft copy. Signature of the head of the organization/agency, project proponent, with stamp and date.
Form 3 Summary. The table provides a structured form for project proponents to detail their proposals under the Swiss challenge method, covering general information, project needs, technology details, required government support, proponent eligibility, pre-feasibility report information, project structure, financials, necessary clearances approvals, and proponent qualifications.
Form number 4, see Rule 79D, content of pre-feasibility report. 1. Introduction. 1. Project formulation. 2. Aim, objective, and methodology. 2. Sector profile. 1. Industry overview with regional specific profile. 2. Key issues. 3. Market assessment. 1. Industry outlook. 2. Demand assessment. 3. SWOT analysis. 4. Case studies. 4. Project concept. 4. Project concept. 1. Project description. 2. Explanation of need and uniqueness of the project. 3. Project components. 4. Site location and analysis. 5. Development needs, public needs and planning considerations. 5. Statutory and legal framework. 1. Applicable laws. 2. Applicable policies. 6. Environmental and social impacts. 1. Environmental impacts. 2. Social impacts. 3. Project-related approvals clearances. 7. Project Financials 7. Project Financials, I Cost Estimation, 2. Revenue Stream, IRR etc. 3. Viability Assessment. 13. Project Structure and Implementation Schedule. 1. Framework for Project Implementation. 2. Contractual Framework. 3. Role of Project Consultant and Project Proponent. 4. Model Concessionaire Agreement. 14. Project Operation and Maintenance Operation and Maintenance Framework. 15. Any other approvals, statutory or otherwise, required to be taken from Government of Rajasthan/Government of India, any other authority. 16. List of forms to be submitted as applicable. 1. Memorandum and Articles of Association. 2. List of participating entrepreneurs. 3. Land documents, if any. 4. Draft Shareholders Agreement. 5. Draft Leave and License Agreement. 6. Draft Procurement Process. 7. Any other documents as required by the administrative department concerned. 1. While preparing this format, the placement of relevant references form in the detailed proposal has been mentioned as above. 2. It is agreed that the above format could be modified or additional information sought by the administrative department concerned at any time in future. 3. The above form is provided in signed hard copy and separately in soft copy also. Excel sheet format to be provided for year-wise information, as applicable, for the concession period. Signature of the head of the organization, project proponent, with date and stamp no. F18/FD/GF and R/2011 SO 135, in exercise of powers conferred by subsection 2 of Section 6 of the Rajasthan Transparency in Public Procurement Act, 2012, Act No. 21 of 2012. Read with Rule 32 of the Rajasthan Transparency in Public Procurement Rules, 2013, the state government. Being of the opinion that it is necessary for 1. The socio-economic policies of the central or the state government. 2. Utilization of resources and expertise of the departments and enterprises of the central government or the state government. And 3. Saving the time, money and efforts of the procuring entities required in inviting and processing of bids individually. Hereby notify that the preference shall be given by the procuring entities to the category of bidders specified in column number 3 of the table given below for procurement of subject matter, specified in column number 2 of the said table, against each of them on the conditions mentioned in column number 4, and general conditions mentioned below the said table. Namely, 1 from any of the following: 1. Rajasthan State Road Development Corporation, RSRDC, 2. PDCOR 3. WAPCOS, a public sector enterprise under the aegis of the Union Ministry of Water Resource, River Development and Ganga Rejuvenation Government of India. 4. NABCON, a wholly owned subsidiary of NABARD. 5. Rights Limited, a public sector enterprise under the aegis of Indian Railways, Government of India. 6. PFC Consulting Limited, PFCCL, a wholly owned subsidiary of Power Finance Corporation Limited, PFC, Government of India. 7. Energy Efficiency Services Limited, EESL, a joint venture company of NTPC Limited, Power Finance Corporation, PFC, Rural Electrification Corporation Limited, REC, and POWRGRID. Added VD Notification No. F21 FD/SBFC/2017 dated 14/9/2017, published in Raj, Gazette EO Part 4 GA, Roman 2 dated 19/9/2017. Added VD Notification No. F21 FD/SBFC/2017 dated 21/2/2018, published in Raj, Gazette EO Part 4 GA, Roman 2 dated 21/2/2018. 2. Added VD Notification No. F21 FD/G and TSBPC/2017 dated 15/09/2023, published in Raj, Gazette EO Part 4 GA, I dated 15/09/2023, and substituted VD Notification No. F21 FD/G and TSBPC/2017 dated 030/7/2024, published in Raj, Gazette EO Part 4 GA, I dated 030/7/2024, for Housing and Urban Development Corporation Limited, HUDCO, for providing consultancy services of designing and planning of works for the projects relating to housing and urban development programs. 3. Substituted VD notification no. F21 FD/SBFC/2025 dated 14/08/2025 published in Raj. Gazette EO Part 4 GA I dated 14/08/2025 for 1. Substituted VD notification no. F18 FD/G&T and R/2011 dated 16/9/2015 published in Raj. Gazette EO Part 4 GA I dated 17/9/2015 for again substituted VD notification NOF 2011 FDG and T SBFC 2017 dated 26/2024 published in Raj. Gazette EO Part 4 GA I dated 26/2024 for 2. Added VD notification no. F18 FD/GF and R/2011 dated 26/12/2016 published in Raj. Gazette EO Part 4 GA I dated 26/12/2016. 3. Substituted VD notification no. F18 FD/GF and R/2011 dated 23/1/2017 published in Raj. Gazette EO Part 4 GA I dated 23/1/2017 for Rajasthan Police Housing and Construction Corporation Limited. 4. Added VD notification no. F21 FD/SBFC/2017 dated and deleted VD dated 16/02/2023 for 5. Added VD notification no. F18 FD/GF and R/2011 dated 13/9/2017 published in Raj. Gazette EO Part 4 GA II dated 19/9/2017. 6. Substituted VD notification no. F21 FD/SBFC/2017 dated 21/3/2018 for Rajasthan Awas Vikas and Infrastructure Limited. 6. Substituted VD notification no. F21 FD/SBFC/2017 dated 08/07/2025 published in Raj. Gazette EO Part 4 GA I dated 08/07/2025 for upto Rs. 25,000 on each occasion with an annual limit of Rs. 200,000. 1. Added VD notification no. F21 FD/G and TSHFC/2017 dated 23/12/2021 published in Raj. Gazette EO Part 4 GA I dated 23/12/2012 added VD notification no. F21 FD/G and TSHFC/2017 dated 11/05/2022 published in Raj. Gazette EO Part 4 GA I dated 11/05/2022. 3. Added VD notification NOF 83 FPS/BCM/SC/Sulab/2021 dated 2012/2022 published in Raj. Gazette EO Part 4 GA I dated 2012/2022. 1. Added VD notification no. F21 FD/G and TSBFC/2017 dated 07/07/2022 published in Raj. Gazette EO Part 4 GA 1 dated 07/07/2022. 2. Added VD notification no. F21 FD/SBFC/2017 dated 16/03/2023 published in Raj. Gazette EO Part 4 GA 1 dated 16/03/2023.
Form No. 8 Summary. The table provides a checklist of documents to be submitted, specifying whether each document is applicable and whether it has been submitted in hard copy and soft copy. Table Summary. The table specifies the sources or categories of bidders for various procurement subjects, along with corresponding conditions or remarks. Academic institutions, skill development corporations, and training institutes are listed as potential bidders for professional services and training programs. The rates for training programs and workshops are determined by the Administrative Department with Finance Department concurrence. Table Summary. The table discusses procurement preferences for various items, specifying the preferred sources or categories of bidders and any conditions or remarks associated with those preferences. The items range from rate contract items with the Director General of Supplies and Disposals to goods and services related to IT and e-governance projects, brassware, hand-printed fabrics, polythene bags, steel furniture, coal, fertilizer, seeds, liquor, milk, uniforms, and security arrangements. Table Summary. hand sanitizer is manufactured by a specific company for COVID-19 management. The table provides information on various items, their suppliers, and procurement conditions, including bedding and furnishing items from specific organizations with rate considerations, security arrangements through different departments with rate approvals, and national flag and khadi cloth from Khadi Bandar. Table 11 Summary. The table specifies security arrangement, technical and other services, the procuring agencies, and the conditions governing the rates for procurement from the listed agencies. Table Summary. The table provides information on the procurement of various items, specifying the source and any relevant conditions or rate approvals. Steel furniture can be procured from village industrial units, with rates approved by the administrative department and a purchase limit. Drugs, medicines, medical equipment, and other supplies are sourced from specific corporations. Homeopathy and Ayurvedic medicines follow CGHS-approved rates. Artificial limbs and assistive devices are acquired from ALIMCO BMVSS, with procurement decisions based on a committee's recommendation. Table Summary. The table describes procurement details for various items, including suppliers and conditions. Table Summary. The table specifies the retail shops for groceries, stationery articles, fennel, soaps, detergents, brooms, and other cleaning supplies, with purchase limits for stationery articles and cleaning supplies. Table Summary. The table discusses the purchase guidelines for catering and dairy products in various government institutions, specifying the sources and procedures for procurement. Table Summary. The table describes the purchase process for catering and dairy products, fuel, meat, vegetables, and bread sweet items for circuit houses, guest houses, Rajasthan House, Vishranti, HCM, RIPA, TAD hostels, schools, etc. It specifies the sources for these purchases, such as government-run shops, cooperative dairies, and established retailers, and outlines the negotiation process for rates through a purchase committee. Table Summary. The table describes the procurement process for fuel, food, printing work, and stationery. It specifies the sources from which these items should be purchased and any relevant conditions or approvals required. Table Summary. The table presents information on procurement processes for various goods and services, including those for jails, printing work, repairs and maintenance, land rental, goods from government entities, and motor vehicle purchases, specifying sources and conditions. Table Summary. The table describes procurement guidelines for goods and services from government entities. It specifies that goods services from state or central government departments boards can be directly procured from them. It outlines the entities that can provide these goods services. Table Summary. The table describes the procurement of various items, specifying the source from which they should be procured and any relevant conditions. Table Summary. Item procurement of works or services by Panchayati Raj institutions from certain committees as executive agencies is deleted. Table Summary. This table specifies the sources for hiring consultancy services, display advertisement, communications, and food and beverage catering. There are specific organizations or departments from which these services must be procured. Table Summary. The table shows substitutions regarding hiring of consultancy services. The consultancy services were changed from PDCOR, WAPCOS, NABCON to PDCOR, WAPCOS, NABCON, and Rajasthan State Road Development Corporation, RSDC. Table Summary. The table provides information on food and beverage catering in official meetings, conferences, and events from various tourism and hotel corporations. Table Summary. The table describes entities that can perform specific tasks, such as original works and repairs, procurement of equipment, and providing supplementary nutrition, along with the associated guidelines and overhead charges. Table Summary. The table describes original works and repairs relating to buildings and other works by Public Works Department, Rajasthan State Road Development and Construction Corporation, and other departments. The overheads are decided by the Public Works Department with concurrence of Finance Department. Table Summary. The table provides information on original works and repairs relating to buildings and other works. The government department, board, or public sector enterprise will be decided by the administrative department concerned with concurrence of Finance Department. Table Summary. The table provides information on specialized services related to IT, electronics and telecommunication, specifying the Center for Development of Advanced Computing, Government of India, CDAC, as the relevant entity and stating that approval from the Finance Department is required before procurement. The table describes exemptions to procurement rules for certain entities and circumstances, including those related to rural women's self-help groups, construction and maintenance work of public toilets, products through e-bazaar, and public utility projects involving public participation. Table Summary. The table provides information on various notifications related to public procurement, including details on procurement subject matter, the procuring entity, and relevant conditions or approvals. Table Summary. Sulab International Social Service Organization is responsible for construction, operation, and maintenance of public and private toilets. Advance amounts are provided for construction, with specific percentages allocated based on the type of toilet. A committee oversees estimates, maintenance, and usage charges. The organization receives supervision charges and is responsible for maintenance for a certain time period. Liquidated damages may be imposed for delays, up to a certain percentage of the delayed construction. Table Summary. The table describes the hiring of professional services rendered by Rajasthan Financial Services Delivery Limited, including consultancy for public procurement, preparation of project reports, and financial and legal matters. The charges for these services are determined by the Rajasthan Financial Services Delivery Limited with the Finance Department's approval. Table Summary. The table describes the hiring of professional services to be provided by the National Institute for Smart Government and the subject matter of procurement related to the establishment of science centers. Table Summary. The table describes procurement details for infra-related work and e-auction services. Procurement decisions for infra work are based on committee recommendations, with a limit. Processing fees for e-auction services vary based on the auction value. Table Summary. The rates for e-auctions platform services are determined by the Finance Department, based on recommendations from a committee.
General conditions. 1. The procuring entity, while procuring the above subject matter of procurement, shall solicit offer from the sources category of bidders specified in the above table, and may negotiate the prices offered in good faith, if necessary. 2. The procuring entity may also opt to adopt the method of open competitive bidding for procurement of subject matters. 3. The procurement from the sources category of bidders mentioned in the above table is subject to delegation of financial powers and availability of required budget provision. 14. In case procurement of goods, works is to be made from a government company or company owned or controlled directly or indirectly by the central government or by any state government or governments, or partly by the central government and partly by one or more state governments, which is subject to audit by the auditor appointed by the Controller and Auditor General of India under subsection 5 or 7 of Section 139 of the Companies Act 2013, or autonomous bodies, registered societies, cooperative societies, other than owned or controlled or managed by the state government, then, approval of the Departmental High Power Committee shall be obtained before procurement. The High Power Committee of the Department shall be as under: 1. Additional Chief Secretary Principal Secretary Secretary of the Chairperson Department. 2. Head of the Department, Member 3. Senior Most Officer of Account Services, Member 4. Technical Officer, if required, Member 5. Officer in charge of the store, Member Secretary. Note: the meeting of the Departmental High Power Committee shall not be held unless the accounts member is present.
Definition. Entrepreneurs Memorandum Roman 2/Udyog Aadhaar Memorandum. A registration document for MSMEs in India, providing them with various benefits and support from the government.
Member Secretary of the Departmental High Power Committee shall be responsible for 1. Preparation of agenda note and minutes of the meeting. 2. Justification of procurement from outside the state, even if the state government organizations/government companies, boards, corporations, cooperative societies, etc. of Rajasthan is capable of supply of goods, execution of works. 3. Preparation of comparative statement of rates of subject matter of procurement from outside of the Rajasthan and within the state. And 4. Preparation of item-wise detail of rates of subject matter of the procurement. SO 165. In exercise of powers conferred by subsection 2 of Section 6 of the Rajasthan Transparency in Public Procurement Act, 2012, Act No. 21 of 2012, Read with Rule 33 of the Rajasthan Transparency in Public Procurement Rules, 2013, the state government, being of the opinion that mandatory procurement from micro and small enterprises situated in Rajasthan is necessary, and likewise, purchase preference in procurement from micro, small and medium enterprises situated in Rajasthan is necessary for the promotion of domestic industry, and for furtherance of the socio-economic policy of the state government, hereby notifies that it shall be mandatory for the procuring entities, as defined in subsection 2 of Section 3 of the said Act, to procure the goods mentioned in schedule from micro and small enterprises only, and also to accord purchase preference to the micro, small and medium enterprises situated in Rajasthan in procurement of the goods not included in schedule, in the following manner, namely: 1. For the purpose of this notification, a. The micro, small and medium enterprises means the micro, small and medium enterprises classified under subsection 1 of Section 7 of the Micro, Small and Medium Enterprises Development Act, 2006, and situated in Rajasthan and recognized by the Industries Department as such. B. Act means Rajasthan Transparency and Public Procurement Act, 2012, Act No. 21 of 2012. C. Form means form appended to this notification. D. Goods means goods as defined in the Act. E. Government means the government of Rajasthan. F. Local enterprise means an industrial undertaking or a business concern or any other establishment by whatever name called, engaged in the manufacture or production of goods, in any manner, pertaining to any industry specified in the first schedule to the Industries, Development and Regulation Act, 1951, situated and have received their acknowledgement of Entrepreneurs Memorandum Roman 2/Udyog Aadhar Memorandum and registered in the state of Rajasthan. G. Deleted. H. Purchase preference means preference in purchase for the local enterprises included in the category under Clause 1A in response to a bid called by any procuring entity, with all other parameters of the bid being the same. And I. Schedule means schedule appended to this notification. 2 goods shall be divided into the following 2 groups. A. Items mentioned in schedule, which shall be procured entirely from local micro and small enterprises. B. All other items, which can be procured from any other source, subject to Clause 4 of this notification. 3. Whenever any notice inviting bid in respect of any item/items mentioned in schedule is issued, a clause shall be incorporated in the notice inviting bid that the items to be procured shall be reserved for procurement only from the micro and small enterprises situated in Rajasthan, as defined in the Clause 1A of this notification. B. 4% of such procurement shall be earmarked for procurement from local micro and small enterprises owned by member of scheduled caste or scheduled tribe. C. Bids received from sources other than those specified in Clause 1A shall not be taken into consideration. D. The contract for supply of goods to the enterprises included in the category mentioned at Clause 1A may be given to the extent of their capacity by breaking the order in part for procurement of goods. And E. Representative of the Industries Department shall also be a member of procurement committees, constituted under Rule 3 of the Rajasthan Transparency in Public Procurement Rules, 2013, whenever the procurement is in respect of items mentioned in schedule of this notification. Such member shall not be below the rank of District Industries Officer. In case the procurement of goods above Rs 10 lakhs is being made for items not mentioned in schedule of this notification, then it shall be optional for the procuring entity to invite a representative of the Industries Department, not below the rank of District Industries Officer, as member of the Procurement Committee. 4. For items not included in schedule, purchase preference shall be given to local enterprises as follows. 2A. Deleted. B. 3. In case the bidding enterprise from outside the state is adjudged lowest, then purchase preference to local enterprises shall be given in the following manner, subject to fulfillment of all required specifications and conditions of the bid. 1. Opportunity shall be given to local enterprises to supply 80% of the bid quantity, with 20% order to be given to the original lowest bid enterprise. Out of this 80%, minimum of 60% would be required to be purchased from the local micro and small enterprises, in case they have also bid, and within this 60%, 4% shall be earmarked for procurement from local micro and small enterprises owned by member of scheduled caste or scheduled tribe. The remaining quantity, out of the above-mentioned 80% and to the maximum limit of 20%, shall be procured from the local medium enterprises in case they have also bid. 2. To exercise this option of purchase preference for 80% of the bid quantity, in such a situation, a counter-offer would be given to the local enterprise, which has quoted the minimum rate among the local bidder enterprises, to match the overall lowest L1 rate received. Deleted. 3. In case the lowest local enterprise does not agree to the counter-offer as per subclause 2 above, or does not have the capacity to provide the entire bid quantity, the same counter-offer shall be made to the next lowest bidder of the eligible local bidder enterprises, in that order till the quantity to be supplied is met. The contract for supply of goods to the enterprises included in the category as mentioned at Clause 1a may be given to the extent of their capacity by breaking the order in part for procurement of goods, in the manner provided in Rule 74 of the Rajasthan Transparency in Public Procurement Rules, 2013. 4. In case a bidder offering to supply the goods is a dealer located in Rajasthan, and the bid prices are equal to the rates offered by local enterprises of Rajasthan, and the quality and specifications of the goods are the same, the local enterprises shall be given purchase preference over such dealer. 5. It shall be mandatory for the procuring entity to record reasons in writing in all cases where items manufactured by local enterprises of Rajasthan are not procured, and purchase preference is not given as provided in this notification, which, inter alia, would be in the case of either non-participation in the bidding process by local enterprises of the state or inability by local enterprise to match the lowest bid price offered by out-of-state enterprise or not matching the required specification to the bid by the local enterprise. 6. The powers to grant purchase preference shall be exercised by an officer or procuring entity to the extent they have been delegated powers for procurement of goods in the Schedule of Powers under General Finance and Accounts Rules or other general or special order applicable to particular department, public sector, undertaking autonomous body, etc. 7. The data of procurement from micro, small and medium enterprises is vital for strengthening the policy, and for this purpose, every procuring entity shall include procurement to be met from micro, small and medium enterprises in their respective procurement plan and achievement made thereto in their respective annual reports. 8. To reduce transaction cost of doing business for micro, small and medium enterprises of the state, having acknowledgement of Entrepreneurs Memorandum Roman 2/Udyog Aadhar Memorandum as mentioned in Micro, Small and Medium Enterprises Development Act, 2006, issued by the competent authority shall be facilitated on furnishing of a self-attested copy of acknowledgement of Entrepreneurs Memorandum Roman 2/Udyog Aadhar Memorandum, as follows. Or as amended in the Rajasthan Transparency in Public Procurement Rules, 2013. A bidding document shall be provided to the micro, small and medium enterprises at 50% of the prescribed cost. B. Bid security for the micro, small and medium enterprises shall be at 0.5%, 0.5% of the value of the quantity offered to be supplied by them. And C. Performance security for the micro, small and medium enterprises shall be at 1% of the amount of quantity ordered for supply of goods. 2. Open bracket, D, close bracket, notwithstanding anything contained in Clause B or C. As the case may be, during the period commencing from the date of commencement of the Rajasthan Transparency in Public Procurement, open parenthesis, amendment, close parenthesis, rules, 2020 to 31032021, the bid security for the micro, small and medium enterprises shall be at 0.25% of the value of the quantity offered to be supplied by them, and performance security for the micro, small and medium enterprises shall be at 0.5% of the amount of quantity ordered for supply of goods. 9. A. 2 copies of notice inviting bids issued for the procurement of goods included in schedule shall invariably be sent to the Office of Commissioner of Industries, Rajasthan, which shall arrange it to upload on the website of the Department of Industries, and to send it further to general managers of all district industry centers of the state. B. For the goods other than those included in Schedule, wherever in the opinion of the procuring entity, micro and small enterprises are likely to bid against a particular notice inviting bid, 2 copies of each such notice inviting bid shall be sent to the Commissioner of Industries for uploading it on the website of Department of Industries. 10. In order to seek purchase preference under this notification, an application, as prescribed at Form A, shall be submitted by the local enterprise to the General Manager, District Industries Center of the district concerned, or to the officer nominated by Industries Department, who, after due diligent examination, shall issue verification certificate for the same. Provided that, in case of any grievance in this regard, an appeal on plain paper may be filed by the aggrieved applicant to the Commissioner, Industries Department, or to an officer nominated by him for the purpose. 11. Every micro, small, and medium enterprise shall be required to submit an affidavit, in Form B, along with the duly filled bid document, to the procuring entity. 12. Before issue of the work order to the micro, small, or medium enterprise, as the case may be, for the requisite procurement, the procuring entity may approach the appropriate authority under Industries Department, not below the rank of District Industries Officer, in order to ensure that the said enterprise, from which the procurement is to be made, possesses necessary production capacity in quantitative and qualitative terms, as required in the bidding document. The Department of Industries, in such case, shall provide the required support to the procuring entity concerned. 13. The following monitoring committee shall monitor the implementation of this notification and removal of difficulties, including grievances made by micro, small, and medium enterprises, namely.
The monitoring committee consists of various members including the Principal Secretary, Commissioner of Industries, Director, Chief Engineers, Financial Advisor, and additional Joint Deputy Director.
Schedule.
Table Summary. The table presents a list of articles included in the schedule, categorized into agro and food-based, animal husbandry-based, building and ceramics-based, chemical-based, engineering and allied-based, electrical and electronic-based, mineral-based, miscellaneous and textile-based. The table presents a list of articles included in the schedule, categorized by industry such as engineering, electrical, mineral, miscellaneous, and textile. The list includes items like buckets, chain links, copper wires, furniture, pumps, fans, cables, and various textile products.
Form A. Apply in duplicate. Application by MSME for purchase preference in procurement of goods. 2. The General Manager DIC, District 1 name of applicant with post. 2. Permanent address. 3. Contact details. A. Telephone number. B. Mobile number. C. Fax number. D. Email address. 4. Name of micro and small enterprise. 5. Office address. 6. Address of workplace. 7. Number and date of Entrepreneur's Memorandum 2/Udiog Adhar Memorandum. Enclose photocopy 8. Products for which Entrepreneur's Memorandum 2/Udiog Adhar Memorandum availed. 9 products for which are at present being produced by the enterprise. 10. 2 products for which purchase preference has been applied for. 11. Production capacity as per Capacity Assessment Certificate. Enclose photocopy of Capacity Assessment Certificate. 12. List of plant and machinery installed 13. List of testing equipments installed 14. Benefits availed in last financial year and current financial year. A. Benefits depositing bid security and performance security. B. Details of supply orders received. I declare that the above all facts given in the application are correct, and my enterprise is producing the items mentioned in column number 10. Date, signature, name of the applicant, along with seal of post. Office of the District Industries Center Certificate, see Clause 10. File No. Date it is certified that MS was inspected by undated, and the facts mentioned by the enterprise are correct as per the record shown by the applicant. The enterprise is eligible for price preference under this notification. The certificate is valid for 1 year from the date of its issue. Office seal signature, full name of the officer, General Manager District Industries Center, rubber seal stamp enclosure. 1. Application 2.
Definition. Entrepreneurial Memorandum, Part 2. a document issued by the Industries Department for registered enterprises.
Form B format of affidavit, see Clause 11, ISO AGDERS. Residing at Proprietor Partner Director of MS, do hereby solemnly affirm and declare that A. My R above noted enterprise, MS, has been issued acknowledgement of Entrepreneurial Memorandum Part 2 by the District Industries Center. The acknowledgement number is dated and has been issued for manufacture of following items. Name of item production capacity, yearly, 1, 2, 3, 4, 5. B. My R above noted acknowledgement of Entrepreneurial Memorandum Part 2 has not been cancelled or withdrawn by the Industries Department, and that the enterprise is regularly manufacturing the above items. C. My R enterprise is having all the requisite plant and machinery and is fully equipped to manufacture the above noted items. Place signature of Proprietor Director, authorized signatory with rubber stamp and date F. 1/8/FD/GF and R/2011 by order of the Governor, Siddharth Mahajan, Special Secretary to Govt. Finance Budget. Notification No. F. 21/FD/SBFC/2017 dated August 28, 2018 S. In exercise of the powers conferred by subsection 2 of Section 6 of the Rajasthan Transparency in Public Procurement Act, 2012. Act No. 21 of 2012. Read with Rule 33 of the Rajasthan Transparency in Public Procurement Rules, 2013, the state government, being of the opinion that in order to encourage entrepreneurship among the youth of the state and increase their participation in the public procurement, providing purchase preference by granting relaxation in the required technical qualifications related to past experience and financial turnover for startups situated in Rajasthan and operated by youth, is necessary for the promotion of domestic industry, and for furtherance of the socio-economic policy of the state government. Hereby notifies that procuring entities, as defined in subsection 2 of Section 3 of the said Act, shall, in addition to the preference granted to the MSMEs VD notification number F. 1/8/FD/GF and R/2011 dated 19/11/2015, accord preference to the startups in Rajasthan for the procurement of goods and services in the following manner, namely, I. In case where the estimated value of subject matter of procurement, as mentioned in the schedule, is not more than Rs. 1 crore on one occasion, the technical qualifications with respect to number of years of experience of a startup in the subject matter of procurement and financial turnover of the startup in past certain years in relation to the value of subject matter of procurement shall be appropriately relaxed to the extent feasible for the procurement of subject matter mentioned in the schedule. It shall be mandatory for the procuring entity to record reasons, in writing, in all such cases where the relaxation to startups is not given as provided in this notification. 2. Whenever the procurement is in respect of subject matter of procurement mentioned in schedule, where the estimated value of procurement is upto Rs. 1 crore on one occasion, a representative of the Department of Information, Technology and Communication, do IT and C, shall be a member of Procurement Committee, constituted under Rule 3 of the Rajasthan Transparency in Public Procurement Rules, 2013. Such member shall not be below the rank of Deputy Director in Department of Information, Technology and Communication. And, for the purpose of this notification, a startup means an entity defined as such by the Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India, and accordingly, has received recognition for the same from the competent authority in Government of India, and also that the said entity is situated in Rajasthan, or an entity approved as startup by the State Level Implementation Committee under the Rajasthan Startup Policy, 2015. B. Schedule means the schedule appended to this notification. And C. Youth means the persons as defined in the National Youth Policy, issued by the Ministry of Youth Affairs and Sports, Government of India, and which is in force on the date of issue of the bidding document by the procuring entity concerned. Schedule.
Table summary. The table shows the production capacity in quantity and value for different products. Table summary. The table provides a template for listing plant and machinery, including their names, quantities, and values. Table summary. The table lists the name, quantity, and value of testing equipment. Table summary. The table presents information on benefits availed in the last and current financial years, specifically regarding bid and performance security by department. Table summary. The table shows the details of supply orders received during the last and current financial years, including the department, purchase order number and date, amount for which the purchase order was received, and amount of goods supplied.
List of items activities included in the schedule. 1. Mobile applications. 2. Websites. 3. Web-enabled applications not requiring FMS. 4. Setting up of service delivery points kiosks. 5. Content management. 6. Social media management secretary to the government. Published in Raj, Gazette EO Part 4, GA, Roman 2, dated 09/2018.
Definition. Micro, small, and medium enterprises, MSMEs. Businesses classified according to their investment in plant and machinery or equipment and annual turnover. MSMEs often receive preferential treatment in government procurement.
Notification No. F21 FD/SBFC/2017 dated August 30, 2018 SO135. In exercise of the powers conferred by subsection 2 of Section 6 of the Rajasthan Transparency in Public Procurement Act, 2012, Act No. 21 of 2012. Read with Rule 33 of the Rajasthan Transparency in Public Procurement Rules, 2013, the state government, being of the opinion that in order to encourage entrepreneurship among the youth of the state and increase their participation in the public procurement, providing purchase preference by granting relaxation in the required technical qualifications related to past experience and financial turnover for micro, small, and medium enterprises, MSMEs, situated in Rajasthan and operated by the youth, is necessary for the promotion of domestic industry and for furtherance of the socio-economic policy of the state government, hereby notifies that procuring entities, as defined in subsection 2 of Section 3 of the said Act, shall, in addition to the preference granted to the MSMEs VD notification number F18/FD/GF and R/2011 dated 19/11/2015, accord preference to the MSMEs situated in Rajasthan for the procurement of goods and services in the following manner, namely: I. The purchase preference shall be given by the procuring entity to MSMEs situated in Rajasthan and operated by the youth by grant of relaxation in the requirement of the technical qualifications with respect to number of years of experience in the subject matter of procurement and financial turnover in past certain years, in relation to the value of subject matter of procurement to the extent feasible for the procurement of goods and services. 2. It shall be mandatory for the procuring entity to record reasons, in writing, in all such cases where the preference to micro, small, or medium enterprise is not given as provided in this notification. For the purpose of this notification, A. MSME means an entity defined as such in the notification number F18/FD/GF and R/2011, dated 19/11/2015. B. Youth means the persons as defined in the National Youth Policy, issued by the Ministry of Youth Affairs and Sports, Government of India, and which is in force on the date of issue of the bidding document by the procuring entity concerned. Secretary to the Government, published in Raj, Gazette EO Part 4 GA, Roman 2, dated 4/9/2018. 1 RJR S4 AJR RJR QUAJR WS IJ RR S4 SRA F